And to bring some record. Kindly oblige you.
Lord, I beg to mention item number 19 and 33, my lord. These two matters may be listed on Friday, my lord, because we are waiting for some instructions from the petitioners, my lord.
Idea is picked for by counsel for the petitioner. 19 and
19 and 33, my lord.
33. Okay.
May I please, your lordship? With the consent of the address, I beg to mention item number 48, lordship. Lordship, in this matter, we have some my senior has some personal difficulty today, lordship. Lordship may taken up after 2 weeks, lordship, in this matter.
48 after 2 weeks.
48. Deeply obliged, lordship.
Please, your lordship, beg to mention item number 39. On last date, additional affidavit is to be filed, my lord. So today we are going to file the affidavit. So kindly matter may be adjourned for the day. A date may be fixed.
Okay. Transfer for the day is paid for by land counsel for the petitioner so as to enable her to file affidavit in opposition in the matter. Item number
39, my lord.
39. Okay.
Kindly a date may be fixed, your lordship.
Transfer for the date will come day after tomorrow. Day after tomorrow.
Okay.
But a motion item, we are filing it today, Lord. In fact, I have given for filing. Lord, I pray for listing on Wednesday, Lord. It's a matter related to pension. Pension is to be given by the Employees Provident Fund Authority, Lord. If possible, on Wednesday, Lord.
Wait, please, your lordship. Well, I beg to mention for listing of the writ petition, my lord. Say that last,
Court master.
my lord.
Give all the prayer for listing to the court master.
Yeah, please. I wait to mention item number 47, my lord. In this case, I have to file an additional affidavit, my lord. Only 10 days time may be granted. Item number 47, my lord.
Okay. This after 10 days, it pays for by land counsel for the petitioner.
Obliged, my lord.
Please, your lordship. I beg to mention item number 34 and
Yes, okay. Yes, Mr. Patel.
as regards the item number 56, that is an election case. I'm told his result is being declared tomorrow. He in fact contested from her. So in that case, subject to indulgence, or can we wait for a few days more, because I'm told he's likely to be elected also. So otherwise I may argue, but the thing is this: if tomorrow something happens, then again day after or within a 1 week time he has to resign. So at least
Okay.
if we can have it some other day. At least.
But Mr. Kotaki, the bad part is that we can't even respond. That is likely to win. We can't even respond.
But I am praying, my lord, that if I can be accommodated for the day.
It's okay. List after both sides are represented. On the prayer made by Mr. K.P. Pathak and its senior counsel, assisted by Mr.
But assisted by Mr. Bhargav Das. D. Das.
Bhargav Das, counsel for the respondent. The matter is adjourned today. List. Give a date after a week.
30 days.
Everything will be clear.
I beg apology, lordship. In item number 48, lordship, there is an interim order that may be continued, lordship.
48. Okay.
Deeply obliged, lordship.
Lordship, I beg to mention item number 34 and 35.
Yes.
Lordship, due to personal difficulty, our leading counsel, Mr. R.P. Fukan, couldn't make it to court today.
No. 34, 35, I think we have heard part.
Yes,
This is a
but
pattern matter.
on last occasion, it was matter listed, my lord. Lordship was particular not sitting, my lord. So, my lord, it was, my lord, subsequently today's listed, my lord. Mr. R.K.
That has been finding very difficult because
Yes, madam. RK
2
Pugan-
weeks have already passed. So I have to
My lord, R.K.
list it
Pugan,
before any other bench because,
his personal difficulties, my lord, he told me also, my lord, yesterday also.
no, but I can't keep it passed. The prayer made by item number
34 and 35.
34, 35. On the prayer made by Learned Counsel for the petitioner. Matter stands adjourned today. List after.
My lord, maybe fix your, no, if my lord, no, keep it part, no, then 12.
No, 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 I'm not keeping it pattern. After 14 days, I'm not keeping it pattern. List after a week, the matter shall not be treated as pattern.
My lord, may I pray, my lord, date be fixed, my lord, this. Because my lord, from
Date after week.
my lord, 6 to 11, I'm not here, my lord. On 12,
6 to 11th, you are not there.
yes, my lord. So my lord, on 12, my lord, this
12/6, okay, sir.
12/6. Highly opposed. Item number 49, my lord.
Just a second.
Only one thing, my lord, is one additional some documents is required to file, my lord. Lord, may allow to file additional affidavit.
No, let it come,
Yes,
because
yes, yes.
without knowing, I can't allow.
Yes, yes.
No, I have a unusual prayer, my lord. Item number 54. It's a covered case. If can't, my lord, reach at before.
We'll upgrade it.
At 2, my lord.
Item 49, my lord, the state respondents have filed their affidavit last week. We need 2 weeks' time to file a reply.
Item,
49.
okay, both sides are represented. On the prayer made by Learned Counsel for the petitioner, list after 2 weeks so as to enable them to file affidavit in replying the matter.
God bless.
Daily list item 1 for withdrawal.
Petitioner wishes to withdraw this petition, my lord, with liberty to file a fresh one.
Why liberty?
My lord, the petition, it's a promotional matter, my lord. The petitioner has not challenged the gradation list, my lord. So he wishes to withdraw his petition, with liberty to file a fresh.
You want to challenge the gradation list?
Yes.
Okay. On instructions, Mr.
S.H. Mahmood. S.H. Mahmood.
S.H. Mahmood, Counsel, Learned Counsel for the petitioner, seeks to withdraw this petition and to approach this court again as the petitioner. Also wants to challenge the gradation list. Who is there? You are there?
Respond number 2 and 3, Lordship.
Okay.
for one.
Mrs. M. Bhattacharjee, Learned Additional Senior Government Advocate for respondent numbers 2 and 3.
Lordship, I'm for 1, 4, 5, and 6.
Your name?
DG,
Ms. D. Jain, Learned,
Water Resource Department.
Counsel for the respondent numbers 1.
1, 4, 5, and 6.
Are present. Common order executive stands allowed. The matter is dismissed for withdrawal with liberty to approach again. Item 2.
Lordship, item 2 is a fixed matter and this pertains to veterinary department, Lordship. Standing council,
My lord, the matter relates to my family pension, already received, my lord, and their matter has become infectious.
okay, then that means standing council, she informed me because of water logging, she could not come.
Already got, my lord.
Okay. On instructions, come on, Mr. A. Manaf,
Yes, ma'am.
Learned Counsel for the petitioner, submits that during the pendency of the writ petition,
ठीक है,
the petitioner has received the family pension. And accordingly, he has instructions not to press the matter, which has been rendered infructuous. Okay. This is M. Bhattacharjee, Learned Additional Advocate, Additional Senior Government Advocate, appears on behalf of the standing council for veterinary department. Is present, matter stands. What is her name? We'll record her name so that, what is her name?
M. Kataki, Lordship.
Yes, on behalf of M. Kataki, Council for Veterinary Department is present. Matter stands dismissed, having not pressed.
Item 3.
Being rendered instructions. Raising non-compliance of order dated 15/9/2022 passed by this court in WPC 1229 of 2022. This contempt petition has been filed. Notice just within 2 days. Give a returnable date after 6 weeks.
Item 4.
Please, Your Lordship. Lordship, the English Council is occupied at another court. I pay for time being, Lordship. Fifty of it.
Thank you.
5.
Item 5.
Non-compliance of order dated 5/8/2022 passed in WBC 4397 of 2022, which was affirmed by the division bench by order dated 5/8/2023, passed in WA 133 of 2023. Contact. That's returnable date same.
Item 6.
Please, Your Lordship. PNRD Council is required. The pension matter. How much time has, what is the period of service you rendered?
My lord, he had rendered, my lord, 27 years service, my lord. 27 years, my lord. He died in harness. My lord, on 16/9/1996.
PNRD is not there.
No, my lord.
Okay, after some time.
Oh, my lord.
After some time.
My lord. Kindly oblige your lordship.
Item 7.
Petitioner is the unmarried daughter of P.V. Subramaniam Lordship, and he retired in 1986 as a junior engineer from Lordship PWD Bokajan, office Bokajan Lordship. Now, he received pension and afterwards his wife also received pension. Now the daughter is before your lordship, and when the daughter wanted to forward her pension papers, being an unmarried daughter lordship, she found that the office wherein her father worked is not in its place lordship. Then she approached the deputy commissioner Bokajan, and she did not get any fruitful reply lordship. Now, the pension papers, in absence of the departmental authorities forwarding it to the AG lordship, it is not being processed lordship. That is the difficulty she is facing.
Is it this? Is it the last?
Is it any letter issued to the Department of Government?
Department can't be missing.
That office is not there lordship. Otherwise, it's PW.
My lord, I have received instruction from Accountant General. Yes, see, the petitioner has approached our office in 2022 itself. Then we have asked her, because this should come through department. Because it had to do through department. Now, it is yesterday's 9/5/2024 letter, then we have not received the documents from the concerned department.
Mr. Sharma is saying that the department itself office is missing.
No, that is why this office,
No, but-
department is to verify now where office will go. Department
Which-
is to
which
verify and
department?
give us.
PWD department.
PWD department.
Yes, Mr. Nayak, can you help?
Lordship, may kindly see the last page of the petition, Lord, page 54.
Lordship, since she could not ascertain whether the office is there or not, she is from Kerala lordship. She wrote to
No,
the
but
executive-
you have received information that there was no such person working there.
Lordship, it's from the executive engineer Digboy and Margherita lordship. And her father served in PWD office Bokajan lordship. Since that office was not there, she inquired here also lordship.
Achha. So something is wrong. Come to page 21. There is a pension payment order from Kerala.
Yes,
So there is a pension payment order there. You can't have a pension payment order at Assam.
And treasury officer is also at honorable.
Yeah.
this was in favor of her mother lordship.
Page 50, yes. The
This
mother
was
received
in
from,
favor of her mother.
No, you see, pension has to be paid by the state government.
Lordship.
It can't be transferred by and paid by another state government.
It was not, it was from lordship may kindly page, turn to page 21, debutable to Assam government, it's written there. It's
Where is that?
just after pensioners portion, debitable to Assam government,
Which page you are reading?
page 21 lordship.
Page 21. Debited to
Lordship
Assam
will see
government.
pension payment order, thereafter the line is pensioners portion. The next line is debitable to Assam government. It's a very old one, Lordship, just creating problem now.
Will request the department to verify.
Lordship. Lordship,
Yeah.
it's there, Lordship, probably it debitable to the government of Assam means probably he was, the father of the petitioner was working under Assam government.
He says PWD, it
Yes.
was in Bokajan.
And subsequent payment, pension was paid from an treasury at Ernakulam, Lordship. It is possible, Lordship, but which I mean,
He
which
says
place-
Bokajan.
but the authority at Bokajan are also denying, Lordship, that is.
This is Diboy and Margarita. Diboy and Margarita would not be Bokajan. Bokajan would be different region altogether. Bokajan is Karbi Anglong.
Yes.
Something wrong here. Try to find out, you'll be able to locate.
Otherwise, Lordship, the PPO number is there, Lordship, and
Where?
by that, Lordship, if possible,
Where?
Lordship, the PPO number is Lordship at page 22. Just before the in the top there is something handwritten, Lordship. After that, there is a number A09954/Assam. Dated for 1989.
Pension to accountant general, Kerala ke dedi. নহয়, যদি ইয়াতে চাকৰি কৰিলে হয়, একাউণ্টেণ্ট জেনেৰেল আসামে পেঞ্চনটো দিলে।
No, that is the number given by the Kerala. Kerala number, they can't track. Assam government, I don't know whether they'll be able to track.
Maybe, but it's written as /Assam. So I'm not sure, Lordship.
Okay, Mr. MP Sharma, on counsel for the petitioner, submits that
Treasury officer rare,
His-
accountant general udar.
that how that the petitioner's father
সব চেষ্টা কৰিব দিয়ে।
had superannuated while working as superintending
Junior
oh, sorry, junior engineer
in PWD office, Bokajan.
the father of the petitioner, namely P full stop B full stop Subramanian, SUBRAMANIAN, had superintended as junior engineer in the office of PWD Bokajan subdivision. Correct.
Lordship.
That's what the petitioner, the next by the counsel for the petitioner is has submitted that the the petitioner's mother this is this page 21 of is of petitioner's mother.
Yes, Lordship.
Family pension rare লিখেছে, family pension না হেৰি।
The petitioner's mother,
Lordship, the PPO number remains the same, Lordship.
okay, the petitioner's mother had drawn on the death of her father, the petitioner's mother had drawn the family pension. So in this regard, he refers to the pension payment order issued by the Office of the Accountant General, within bracket A and E bracket close Kerala, comma Trivandrum, where the PPO number is mentioned as KO 9954/Assam, And it is submitted that the said pension payment order contains an entry that the same was was debitable to the Assam government under head of account 8793 ISS Assam. Next, it is submitted that upon inquiry, the petitioner has come to know that the office of the PWD Bokajan is not located in the earlier address, and she has not been able to track the said office. It is also submitted that being an unmarried daughter, the petitioner is entitled to receive family pension under Rule 143 of the Assam Services within bracket pension, bracket close rules, 1969. Next para. This is circumstances, the court is inclined to request Mr. P. Nayak Leonard, standing counsel for the PWD, make an endeavor to collect information as to the office of the executive engineer, Bokajan subdivision.
Lordship, that instruction in fact placed, Lordship.
Okay. Mr. M.P. Sharma, counsel to the petitioner, also heard Mr. P. Nayak, Leonard, standing counsel for the PWD, representing respondent numbers.
Doesn't apply.
1, 2, and 3.
Two,
Oh, sorry,
Lordship.
1 and 3.
1 and 3, Lord.
1 and 3.
I put the
And, Mr. You are appealing for
I am for 2, Lordship.
your name?
RS Ronghang.
R.S. Ronghang, Leonard, standing counsel for respondent number 2. And Mr. P. Nayak, Leonard, standing counsel for PWD, representing respondent number 3. Mr. Shi Sharma, C. Gowel, Leonard, standing counsel for the respondent number 4. Mr. Nayak will be for 1 and
3, Lord.
1 and 3.
1 and 3.
Okay. Next, pursuant to order dated 6/5/2024, Kamadi Leonard, standing counsel for the PWD, has produced a copy of letter dated 30/4/2024, received from the executive engineer PWD, Borpatha Road Division, Siloni Jan, stating that in their office there is no incumbent by name of late T.B. Subramanian, served or retired as junior engineer from the said establishment. In this, next, in this context, he has also produced a copy of letter dated 30/4/2024, issued by the additional chief engineer PWD within bracket R&B bracket close Hills, Assam, Difu, indicating that he has received letter from the executive engineer, PWD, Borpatha Road Division, Siloni Jan, to the effect that the said person has not retired, public superannuated from PWD, Borpatha Road Division, Siloni Jan, as per record available in their office. Is also the Learned Standing Council for PWD has also produced a copy of letter issued by the letter dated 2/5/2024 issued by the Deputy Secretary PWD, AAAC, DIFU, referring to the hearing before referred letter of Additional Chief Secretary PWD dated 30/4/2024.
Kerala party family pension delay issue.
Documents
Next, that view the matter. In the instructions produced, the court is inclined to adjourn the matter so as to enable the petitioner to bring on record better particulars regarding any documentary evidence, if available, of a father rendering service as junior engineer in the establishment of PWD in the state of Assam. List after
at least 4 weeks.
list after 4 weeks.
What have been, I think in this matter, AG Kerala is also a necessary party. Because he issued the PPO, he issued the family pension. Even now, if it is, she is entitled lordship, that will have to issued by the AG Kerala only lordship. Let him
Just take instructions.
let him
You have heard Mr. Nayak. We are not putting it on record, but you have heard him. Take instructions.
Lordship.
We are returning your documents.
lordship.
Item 8.
My pleasure, Lordship. Last occasion notice could not be issued, Lordship. There was some problem in the synopsis and the prayer of the petition. I have already corrected it, Lordship. I have already filed it.
Okay. But Mr. G. Das, Learned Counsel for the petitioner. That's correct. No, not continue. Referring to by referring to order dated 8/5/2024, it is submitted that the necessary amendment has been carried out by the petitioner in the petition. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the entry made in the ACR for the year, which year?
2022 to 23, Lordship.
2022-2023. which was not communicated to the petitioner. Correct? It was not communicated to you.
No, Lordship.
Okay. Next, please.
And afterwards,
Issue notice returnable in 4 weeks. Requisite extra copy of the writ petition be served on Mr. B.K. Singh and his standing counsel for the respondents within 2 days. List after 4 weeks. Stop this.
Item 9.
Lordship, kindly pass over for the pending motion.
Just one minute.
Otherwise, my lord, only notice has to go in this.
Just one minute. This I open, I won't know what
Yes, my lord.
what I'm looking at. This one. Here only notice will go. Your name?
Take over, Lordship.
Ms. A. Gogol and counsel for the petitioner, as well as Mr. B.P. Bora, learned standing counsel for the Health Department. You are for all the respondents?
Yes, my lord, all right.
Waiting for all the respondents. Next paragraph. Also notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned standing counsel for the Health Department in the course of the day. Next paragraph. List after 4 weeks.
Item 10.
In this case, by the petitioner Celeste Lordship, page 31, under selection and appointment of the respondent number 13. This is the reply under RTI Act. My page 32 is my lord, CL number 31.
Yeah, you should notice. Had Mr. M.H. Ahmed, learned counsel for the petitioner, as well as Mr. A.
I bought
I. Botapur, learned standing counsel for the PHE. Who's for PNRD? You as well?
10 and 11.
Mr.
P. Handling.
P. Handick, learned standing counsel for the PNRD, appearing for respondent numbers
10 and 11.
10 and 11.
7 only, Lordship.
Okay, and this is Empathy Sarji, learned additional senior committee advocate, appearing for the state respondents. You will be for respondent number
And for respondent number 7 only, Lordship.
7. Okay, for respondent number 7. The selection and appointment of respondent number 13 is received in this petition filed under Article 26 of the Constitution of India. Issue notice returnable on give a fixed date of after 5 weeks. Issue notice returnable.
24/7.
Issue notice including notice on the prayer for interim relief returnable on so and so. Petitioner shall serve extra copies of the petition to the learned standing state and departmental counsel in course of the day. Next, the petitioner shall also take steps for service of steps within 2 days for service of notice on the respondent number 30 by registered post with AD. As per the learned counsel for the petitioner shall collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph. The selection and appointment of respondent number 13 as Jal Mitra
Lordship.
shall be subject to further orders that may be passed in the writ petition.
Obliged.
Item 11.
That relates to the continuation of the suspension order of the petitioner. The petitioner suspended page 19 in exam 5 is the suspension order of the
Suspension order is 7/9/23.
7/9/23. Till date, Lordship, we have not
Issuing notice.
Lordship, may I submit one thing, my lord? It is a matter of deemed suspension. The petitioner has got the bail on the month of November 2023. After that, he has not, I think, informed the department because no documents have been annexed in the.
You take information.
Paragraph
Because
7, I have stated.
if he has been on bail, I think he will.
He has
definitely
already
inform.
approached, Lordship. Paragraph 7, I have categorically.
Let us find out.
This is clear violation of the settled law. of
We don't know unless they come up, we don't know whether there's a violation or not. But Mr. ABT Hopland, counsel for the petitioner. And Mr. MD Boral and it's standing counsel for the transport department,
Corporation department,
which a corporation department appearing for
all the respondents.
all the respondents. The deemed suspension of the petitioner by order dated 7/9/2023 on his arrest in connection with the criminal case is assailed in this writ petition filed under Article 226 of the Constitution of India. On the ground that there's been no order for extension of his suspension. Next one. You know, Mr. Hawk, there's certain things I can't remove from my head. That is the problem. When you say you are relying on paragraph 7, in respect of paragraph 7, you have not annexed any document. And therefore you say that you have submitted a representation and that's a matter of knowledge. In your affidavit, you say it's a matter of knowledge. If you have given a representation, it can't be a matter of knowledge, it has to be by record. So you can't have it.
Additional affidavit.
No, that's okay, but representation can't be on personal knowledge. There are many things which has to be seen. Therefore, these are elementary principles I can't. remove from my head. Institution office returnable in give a date after 15 days we are giving 2 weeks after 15 days give a date. You should notice returnable on so and so. Requisite extra copies of the reparation will served on the learned department counsel in course of the day. Next paragraph. In view of the well settled law in the context of continued suspension. The respondents are directed to positively either file their affidavit in opposition or provide sufficient instructions to the learned departmental counsel to respond to the court queries on the next date. Next paragraph, the learned standing counsel for the corporation department shall send a downloaded copy of this order to the concerned respondent authorities to obtain instructions
Lordship,
based on
19th of June,
deeply obliged, my lord.
item 12.
But at this juncture, only pay for notice something, my lord. This regarding commission and appointment of the persons, my lord. And
that was long back.
no, my lord, here this DLC has rejected my plea case on the wrong plea, taken by wrong plea, my lord. Lordship will find at page 35, my lord, 34 and 35, my lord.
Right.
This is the proposal submitted by the executive engineer. He has wrongly quoted the date of application, my lord. 35, Lordship will find Navajit Bhagavati. Date of death is 3/8/15. and date of application is 6/6/19. And because of this, my lord, now lordship will find the minutes of the meeting 36. Relevant para, my lord. Navajit Bhagavati 29, serial number 29, lordship is found. Same thing as the proposal in respect of Sri Navajit Bhagavati, son of late Mukut Chandra so is examined. The father of the applicant was died on 3/8/15, but the applicant applied for appointment on 6/6/19, that is after almost 4 years. His proposal cannot be considered as per para 3 of the OM so 16/2015. Now lordship will find the application of the petitioner that has not been taken into consideration. Lordship will find at page first application, my lord. First application is at page 18, lord.
Yes.
That was executive engineer, public health engineer, dated 5/10/2015, and it was submitted by the petitioner's mother. Lordship will find the vernacular at page 19, lordship. Immediately after 2 months, that was submitted, my lord. Vernacular lordship will find annexure 19, lordship.
Yes, I've seen that.
So my lord, if it is submitted on 5/10/15, then certainly 19 cannot be, my lord. And the fact remains, my lord, it was not rejected for want of vacancy, my lord. It was rejected only on the wrong. The date of application has been mentioned, my lord. That is why, my lord. And for that, my lord, I cannot. I should not suffer, my lord, because already thereafter also we have submitted the application to the minister concerned.
There are several recent Supreme Court judgments where this has been deprecated. Even if you submitted, your mother submitted an application.
That part will convince your lordships, my lord, since this honorable High Court also said that as per the Achyut Ranjan Das case, as well as this Fazilun Nessa case, it has been said that since the delay part, once the person has to be considered and rejected on the basis of no vacancy, my lord. Had it been so, then I do not have any claim, my lord.
No, it's not a question of vacancy. Your application itself is belated.
No, the application.
You see, your mother could not have applied. I don't know any clause in the compassionate appointment circular which permits mother to apply for the son.
Yes, the mother has applied for the son.
No, I don't know whether it can be done. If you don't know how to write your application, you are otherwise also ineligible for any service. So your mother applied for you, which is not a
that fact lordship will consider, my lord, after the notice is served, my lord.
You are dismissing it.
No, my lord, since then I may be allowed to rely on some of the judgment, my lord. Some other day lordship will fix. I will rely on that judgment.
Okay. Day after tomorrow.
Lordship.
We reach retreat and counsel for the petitioner. Please, short adjournment. Prayer is allowed. Mr. I. Whatever done at standing for the
Respondent 1 and 4. Lord.
respondent number 1 and 4 and Mrs. M. Bhattacharya and the government advocate appearing for the respondents.
3, lordship.
2 and 3 present. It is done. Day after tomorrow.
Item 13.
This one is our A&M nurse. Their main grievance is the fixation of pay on the ROP 1989. Lordship has passed a judgment recently. Lordship, that judgment is 97, page 97. It is covered case, my lord. Lordship directed consider their case. And the ROP, they are getting lesser pay, and other departments are getting more pay, and similarly situated persons are getting more payment. Their pay fixation.
Property part is 102. 101 start.
Okay, we will issue notice, Mr.
Yes, sir.
Finance. Heard Mr. A. Ahmed, then counsel for the petitioners. Also heard Mr. D. Upamanian and standing counsel for the Health and Family Welfare Department. Finance,
For the eight.
you are there. Miss
A Bhattakur
A. Bhattakur, then it's standing counsel, the land council, appearing on behalf of Mr. P. Nayak, standing counsel for the Finance Department. And Mr. B. Sharma, the next standing counsel for the Accountant General. From Assam. By filing this writ petition under Article 226 of the Constitution of India, the petitioner is raising a grievance regarding refixation of their pay pursuant to ROP rules, 1990. Next one, issue notice. Returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Donut State and Departmental Council within 2 days. Next one, list after 4 weeks.
Highly obliged.
Item 14.
May I please? Please, Your Lordship. Your Lordship, the petitioner herein is an employee of the State Bank of India in the position of senior management grade 5, grade scale 5. Your Lordship, there was a role-based certification examination that the petitioner had to take for promotion, for his promotion. Your Lordship, he has been applying for the said examination. He has to take an online course for 2 days, and he applied for that course to his higher official, that is respondent 3, 19 times since the month of January. But he was not allowed without him giving any reason. Thereafter, thereafter the date went away, and then he lost the promotion opportunity. My lord will find the role-based certification course guidelines in page 130.
14.
Please try to tell us what is the prayer in your writ petition? I don't follow it. What is the prayer in the writ petition?
It is therefore prayed that your lordship will be graciously pleased to admit this petition, calling upon the respondents to show cause as to why an appropriate writ, orders or direction like nature should not be allowed against the respondent, and as to why the, my lord, here the word petitioner has been inadvertently made. It should have been respondent, my lord. My lord may allow me to change this.
On the prayer made by land counsel for the petitioner, she is permitted to make necessary correction in the prayer made in the writ petition. Now, okay, now what is the prayer, remaining prayer?
Remaining prayer is that, my lord, the petitioner's right to equal opportunity has been harmed, my lord. And therefore he has, my lord, if I may request my lord to direct my lord's attention to page 135.
No, we have not yet finished. You have not understood. Now, you say that why the respondents should not be held personally liable. You're referring to which respondents?
Respondent number 3 and letters
again-
were also sent to respondent.
Again, that respondent number 3 is not there in your prayer. Okay. Now, in a writ petition, you want a declaration from this court that somebody has violated right to equal opportunity. My question to you is that can a writ to that nature be issued by the court to declare that somebody has infringed your equal rights? Is it permissible for a writ court to give that declaration?
My lord,
Any case law on the point?
my lord, here the respondent itself.
No, that's
is the
okay.
state-
It's not that I have not understood the prayer. I'm asking you two questions. The prayer of this nature, is it permissible under the, under any law? Number one. Second question is, do you have any authority on the issue where the courts have issued mandamus or a declaration that somebody has infringed your equal rights, equal opportunity?
My lord, currently I'm not carrying the judgments, but
Dismiss your writ petition,
then, my lord, I pray that let me withdraw the writ petition and file fresh.
right? Because this is not this is not an appropriate court to approach. Then your third prayer is that there should be charges against the appropriate section of IPC, CRPC imposed on the officials in individual capacity. I don't know how CRPC can be charging offense.
My lord, then let me withdraw the writ petition and file
Okay.
fresh.
File fresh, no, we are not giving you that.
My lord, because otherwise, my lord, my petitioners will not get justice, my lord, because he has
No, no,
not been
we are
given an
not-
opportunity.
I
my lord.
told
He has
you, under the no
approached-
law,
He has
which
approached,
is the law you are referring to? Equal opportunity under which act?
my lord, then give me one opportunity to refile the case, my lord. Let me withdraw and refile.
No, no,
I'll
this is frivolous. You want a vague order from the High Court giving a declaration that charges under IPC, CRPC should be framed against respondent number 3.
My lord, it is also important to say
I
that we have
understand.
also filed a
One,
defamation suit.
under CRPC, what is
My
the
lord, he's
charging?
a whistleblower and he
No,
has
no,
been
that's okay.
harassed or mentally tortured to the extent that he has not been given these employment opportunities.
I don't know. In my college days, I also whistled and somebody slapped me.
My lord,
So I
this
don't know the
obedience
context.
to
You
the
see,
speech is of a
whistleblowing,
vindictive nature, otherwise-
whistleblowing must be in some context. When I am speaking of my young age, and
No,
I am
my lord,
speaking
under
about whistle, you
whistleblower
say,
policy, he has filed the whistleblower
understand.
complaints, my lord.
But
We have
if you have come under Whistleblowers Act, that protection, you have to spell it out. Then under Whistleblowers Act, how can there be a charging provision under IPC and CRPC? Please tell us. It is your reputation. Please tell us. Since I am unaware of these provisions, you'll have to tell us. Otherwise, we can't allow this, and in light of Sikiri Vasu, we can't allow this repetition. It's not even a wastage of time, it's a wastage of unnecessary pendency. Sikiri Vasu is very clear. If you have a complaint, you go and lodge it before the authorities.
We have
I can't-
lost the complaint, your honor.
Where is that?
There are numerous complaints, your
No, no,
honor.
where is that?
Starts
Let us
from
see one.
Annexure 17, starts from Annexure 17.
Give one page.
number-
Tell me one page.
Yes, my lord. Page number 70,
70.
yes.
Where is the service regulation of State Bank of India? Do you have a copy of that service
I'm not
regulation?
Carrying the copy currently, yeah.
The difficult part starts when you request me to read something. Now you have shown me this page 70.
Yes, my lord.
I have read it, page 70, I have read it.
Yes, my
You
lord.
see, now you say, last paragraph,
Yes.
if I don't receive communication on my request to proceed against so and so on ground of defamation by 29/2/2024, I would presume that the bank has no objection to it and I will proceed in the matter. So it's your unilateral declaration that if you don't receive by this date, you will proceed. Now, who has stopped you?
My lord, we have already proceeded with the defamation suit.
So then you don't have a right, you can't proceed in the writ petition and
We are
then,
not here for the defamation part, my lord. We are here only with regards to the fact that he was not
I'm
given
really sorry.
then
You see,
the opportunity
in
to
a few
participate
moments-
in the examination.
A few moments back, I said that there's something in my mind, I can't throw it out. Correct? You heard me. Now, you see, order 3, rule 2. And also the principles of civil CPC, which is ingrained in the writ petition also. Principle of constructive res judicata. You can't come to court, one pair here, one pair there, one pair, third pair, another place. You can't do it. It's a there's a term of litigation. What was it called? This litigation should not be encouraged.
But my lord, we are here only with regards to his promotion, my lord. Only with regards to the fact
That's
that.
why I
he was
made you
not
read.
given the
That's why when you said one statement, we made you read the prayer. In your prayer, I don't find anything concerned with promotion. I made you read it.
That is why, my lord, I may be allowed to.
No, no,
withdraw
no,
it
no,
in
no,
the
no.
file because otherwise, my
No,
lord,
no,
he has.
can't. You should have
My lord,
read
it's a-
that. You
It's
see,
he's around, he's almost close to his superannuation. And this was the last promotion opportunity that he had.
but that's not the prayer. So we dismiss your petition. If you have any right, you come again, because that's not the prayer. We can't permit you to make a volte-face after the questions being asked. This is nothing to do with promotion. Your prayer is very specific. You can't encourage that.
My lord,
You see, the impression we are getting is that we ask you questions. If it is uncomfortable, then you say that I change my prayer, I change my writ petition, I amend the writ petition. That's not how we can permit you. What do you call, you waited for the response of the court, and then you try to amend the writ petition to suit it. If I say A, then you will say B. If I say B, then you will say C.
no, my lord, I'm only on the point that
No,
his
no.
promotion opportunity is lost because he has been not given the opportunity. It was just a 2 days learning
I
online
know
learning examination.
you made me read page 70. Any other page you want me to read?
Yes, my lord. My lord, page number 76 also. It was sent to respondent 2. Right, may I read, my lord?
Where is your corresponding statement in the rate petition that uh, for the purpose of in-service training,
Yes, my lord.
you'll have to apply in mandatory and in mandatory
Para number 12, my lord.
para 12.
We have also annexed the guidelines.
Where is that?
That is in page number 130.
130.
Yes, it starts from page number 130. And the relevant portion that says that it is mandatory is in page number 135. Uh, 135E, the letter E. The concept of 2 days training holiday was introduced in 2020-21 to enable the official to attend the online webinars and go through the study material before taking the examination on the second day. The 2-day training holiday shall continue for financial year 23-24 for one attempt of role-based certification, which will continue to be treated as deputation. Thereafter, serial number 10, CDS core. A 5-mark weightage in CDS is linked to the completion of role-based certification, and completion of all specified e-lessons shall continue. 5 marks, except for the employees under partial exemption, 5 marks of mandatory learning will be awarded only when all specified e-lessons and the applicable role-based certification, RBI mandate certification are completed, uploaded, and approved in HRMS under role-based / TEGS certification. Thereafter, it continues to the next page. my lord. D, serial number D.
You're an employee of which category?
I'm an employee of senior management grade scale 5 category. My promotion was due for grade scale 6. And
Senior manager, grade 5.
yes, it is, this certification course is mentioned in page number 131. It's a mid-career certification, page 131. In mid-career, in the table, it's written as a mid-career.
I don't know, whatever documents I wish to see, it's incomplete. Now, when I'm reading this guidelines,
Yes, my lord.
I find somewhere in page 131,
Yes, my lord.
there's a reference to annexure H. Again, you have conveniently not annexed annexure H.
131 annexure H, my lord.
There's a box,
Yes, there is a box only. That is a
row 5, column 4,
Yeah.
annexure H. All employees from award staff to officer up to SMGS 4, 5.
my lord, serial number Roman numeral 3, the one before that, my lord.
Pardon me?
Mid-career correct certification in the same page. Serial Roman numeral 3.
So where is that J? Certification,
Oh, my lord is asking about the annexures. Annexures, I do not have it with me. That's why I cannot annex it. But otherwise, my lord, he's an eligible candidate, my lord. And the online course, the 2-day online course was mandatory for obtaining the 5 marks. Without that mandatory course, you would not be eligible for the promotion. And the list of eligible.
where is your last representation?
Just a second. Annexure number 27, page number, my lord, 1 annexure 76, which my lord has already read, and the same was sent to respondent number 4 as well. In annexure number 27, which is annexure number, it starts from annexure 21, page 88, 18/3/2024. My lord, with regards to the promotion, page 90,
Which was the page you said? I forgot.
page number 88, it starts.
88.
His last representation was in the month of March, 18 March.
Just a moment.
And my lord, with regards to the promotion.
Just a moment.
Yes. My lord, his prayer is in page number 90, para number 4, my lord. For the promotion, his representation is in paragraph number 9, in page 90, paragraph number 4. GM IACO Guwahati is not responding to my request for 2 days training to take role-based certificate examination.
Besides Das, learned counsel for the petitioner seeks to withdraw this petition and to refile it, limiting her prayer only with regard to the denial of 2 days training holiday, so as to enable the petitioner to take
Role-based mandatory certificate examination.
what is that name?
It's role-based mandatory, role-based certification exam.
RBC examination, which is an essential requirement for claiming promotion, claiming entitled for promotion. Where is allowed, matter stands dismissed on withdrawal with liberty as paid for.
Much of it.
Item 15.
Just
Here the petitioner lordship.
Yes, is this available in the presidential order?
Lordship.
Is this community name appearing in the presidential order 1950?
No, Lordship, his name is in the state list, Lordship, in the WPC, issued by WPT and BC department, Lordship, at serial number 31. Of government.
Which page? Which page?
Lordship, I have given the statement only, I could not collect it, page 5, paragraph 2. The petitioner belongs to Bishnupriya community, which falls at serial number 31 in the list of other backward classes government of Assam, WPT and BC department, notification number so and so, and is permanently domiciled in the district of Assam. Also, the dispute is not that my certificate is not genuine. The dispute is that my name is not, the community is not reflected in the central list of state of Assam. This is the dispute. And similarly situated persons, I have annexed the Lordship, some person's name also, Lordship, who are still working, serving in CRPF and other CAPF departments, Lordship, with OBC category from belonging to Bishnupriya Manipuri category, Lordship.
Okay, issuing a notice then.
Lordship.
But Mr. A.R. Taibuldar, learned counsel for the petitioner, as well as Ms. R. Gugi learned CEC appearing for the
Respondent number 1 to 5.
1 to 5. And Ms.
So she's not for respondent 6.
Your spelling I always miss out, huh? He'll do it. Court counsel will give it. Then it's standing counsel for respondent number. You're for respondent number 6.
Yes,
Respondent number 6 and
for respondent number 7.
Ms. A. Talukdar and Gamit Advocate appearing for respondent number 7. Next, Paran. the order dated 2/9/2021, thereby cancelling his appointment to the post of, which post? CRPF,
Constable in the.
Constable CRPF, is assailed in this petition filed under Article 226 of the Constitution of India. It is projected that the petitioner belongs to OBC, being a member of Vishnu Priya Manipuri community, which is enlisted in the state list as OBC. Next, one, the issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the, we give a date after 4 weeks. Extra copies of
17th
the
of July.
extra copy of the writ petition, copies of the writ petition is served on the runner CGC, State and Departmental Council within in course of the day. Next one, list on so and so.
Obliged.
Item 16.
Well, matter partners, the non-conversion of the petitioner matter from armed branch to unarmed branch matter. Here, petitioner matter were initially appointed as constable matter in the year 2008 matter. Thereafter, in the year 2013 matter, the Director General of Police matter has issued a circular matter for conversion of the unarmed branch matter to armed branch to unarmed branch matter, and we laid down some.
Okay, issue notice. But Mr. S. Hockland, counsel for the petitioners. The non-consideration of the application of the petitioners for conversion from Assam Police Armed Branch to constable in Assam Police Battalion within bracket unarmed branch. Stream, STREAM, stream in DEF, capital DEF, is assailed in this petition filed under Article 226 of the Constitution of India. Issue notice, including notice on the trade for interim relief, returnable in returnable, so give a date after 4 weeks.
17th of July.
Mr. CKS Barwal, Government Advocate, accepts notice on behalf of all the respondents. Requisite extra copies of the writ petition is served on him in course of the day. Say, issue notice, including notice on the prayer for interim relief. Prayer for interim relief shall be considered on the next date of listing. List on so and so.
Item 17.
Yes, Mr. Roy.
My lord, this case, my lord, quite different, my lord. My lord, the principal of GMC is my lord. In his report, my lord, he deny my recognition as a disability. My lord, but he admitted that I have the disorder, fluency disorder. Now kindly see page 59.
Where is the document?
Page 59.
59.
Yes.
59 years.
Serial number 2, my lord, Ilyas Ahmed. Disability certificate cannot be issued as it is a case of fluency disorder and does not fall under speech disability under Right of Person with Disability Act 2016. My lord, the definition of the disability under the 2016 Act and the definition of the disability under the 1995 Act totally different, my lord. My lord, he is in the understanding in the earlier mindset, my lord.
What is it? Now the 2016 Act is
Yes.
in force.
My lord, in petition, I have.
Disability Act 2016. Yes, in the petition where you have said that.
Yes, my lord. Paragraph 14, my lord. Paragraph 14, page 19, my lord. Then page 20, my lord, kindly see. Person with disability, my lord. Person with disability means a person with long-term physical, mental, intellectual, or sensory impairment, which in interaction with barriers hinders his full and effective participation in society equally with others. But in 1995 Act, my lord, that quite different. In 1995 Act, disability defined, my lord, person with disability means a person.
No, you must show that the nature of disability you are having entitles you to a certificate.
Yes.
You only say that you have a fluency disorder.
Yes.
Fluency disorder can be two things. Number one, you can be stammering. And number two, it can be that your speech is slow.
Yes.
So what is your disability? How can you find out what is the disability?
My lord, in the certifying authority.
No, it was Right of Disabilities Act. What is the name of the act? Right of Persons with Disability Act.
Right of Person with Disability Act 2016.
Rights of persons.
With.
Yes, where is it designed? Where it is, which provision?
My lord, it's defined. Section 2S.
Communication.
S, my lord, person with disability.
Communication into this format, communication language, display, date, tactical communication, science, print, so and so. Written audio, video, visual displays. Does it say about speech disability? What do you call the? You say that you are the fluency disorder. Where is that? What is the nature of work? Where you applied? Which post? Beyond.
Beyond, my lord.
Okay. Now, where is this? Where is the disease which entitles you to the rights of disability?
I am under section 3, my lord.
just, Vishwanath, just see, there is rule. In this act, there is a rule which is called, rule number 9.
But actually,
In rule number, sorry, not rule number 9, I'm sorry, I'm wrong. This 14A,
Rule 14.
14A is regard to the union territory shall notify the so-and-so with benefit discipline and apply for high support requirement. Correct? Now, this contains a chart, parameters, severity of physical disability is given.
Yes.
Speech disability is something I can't find. Slowness in speech, I don't find that this is there.
Malad,
Look, I'll tell you, now, my examples are always horrible. This is one of the bad examples I am giving. Now you see, I take 5 minutes time to wear my shirt. The reason is that my hands are very slow. I can't put it in. And therefore, in the morning, these two things happen. When my button is loose, I have to sew the button. I do my things myself. So if I have to sew the button, I can't put the thread into the eye of the needle. I'm very slow. It takes me more than 5 minutes to put the needle thread in the eye. So now, can I claim that this is a disability and therefore I must be given a special treatment? Because you are saying you are slowing speech. But it must be covered somewhere. It must be well defined that this is a disability. So otherwise, I can't put my button very fast. You may do it in a jiffy. You may get yourself dressed up. I'll take 5 minutes to do it. So is it a disability which is recognized and entitles you to a protection under Rights of Person with Disabilities Act? This is something you'll have to show. We'll take a 5-minute break and 2-minute break and come back.
Yes.
Because the parameters are given in the rules. This is what I read earlier. So you have to show that it has some connotations of semblance of fitment into that rule. The disability must be some. For example, if there is a say disorder in the bones of my leg, I can't walk. Then there's a parameter to assess it to be slow. So please explain on technical terms. Just take a break and come back. That?
Malad, page 39.
13.
39.
39.
But I have challenged the constitution of the board itself, madam. The
Speech and language disability.
which is this Lampai RT meet.
You have this circular of 4/1 to the 2018. Do you have a copy of that circular? referred here. SO 76E.
My lord, on this context, my lord, the apex has already held, my lord,
Yes.
the some disability inclusion or exclusion of disability, it itself an barrier, my lord. But if your lordship,
No, but what is this disability? You are referred to as this disability. Do you have that circular? No.
That-
I don't know why he has done it. You see this in the net, this 76E of 2018 dated 4 January 2018 is available. Issued by Ministry of Social Justice and Empowerment, Government of India. It relates to 8 disorders: locomotor disability, visual impairment, hearing impairment, chronic neurological conditions, persons affected with blood-related disorders, developmental disorders, mental illness, and multiple disabilities.
my lord, those are the benchmark specified disability, my lord.
No, you must bracket it with, I gave you an example. I can't put the thread in the eye of the needle. You may do it in one go, I can't do it. I'll
But-
take 10, 15 clicks and then it goes in, correct?
But
So is it a disability just because I can't put the thread in the needle, eye of the needle? Is it a disability? Because you
it
have
is a
to,
disorder, man.
it's a disorder.
Yes, my lord, he
No,
inserted.
it's not a disorder.
No,
Because
matter.
I have consulted a doctor on this. It's not a disorder. It's merely what you call it's lack of focus at one point of time. When I'm putting the thread in the needle, I lose focus. It's not a disease. It's because I have so many things. I have to come at 10:30 to reach here. And therefore, the ignorance I can't do because I got it checked. When it comes to medical issues, I get it checked.
But it
Because when you say it's a speech
the-
disability, you see, you'll have to, it will be dyslexia. You just take up what is the name? Dyslexia. So then only these are, if it's a dyslexia, I just forgot. Just let me check. It doesn't say about that speech disability.
my lord, this
Dyslexia, yes, right. It's a learning deficiency. Then got nothing to do with my disability
But-
to put the thread in the eye of the needle.
my lord, those the list which has been published by the government, my lord.
Where is the Supreme Court judgment? Let us see. Thank you for putting me right, at least dyslexia. I've almost forgotten the word.
My lord. Paragraph 18, my lord. Here is the case also, my lord. This persons does not fall under the 2016 Act and also does not meet the benchmark disability, my lord. 18 to
Because Mr. Roy,
yes.
I spent most of my practice time in the civil court. We also had MSCT courts there. And hundreds of cases I have seen where people can't walk, they have to be brought on wheelchair, crutches. And when the matter is over, we find them walking out and going out. It's not one, hundreds of. In fact, I am amazed how after the MSCT award, people can walk so fast. The person who was in wheelchair inside the MSCT court, the nature of sprint I saw in the people, I am amazed.
Similarly, in this.
That's why we say got his grade. Once award is given, he is fit. Those things we have seen. So it's very easy to say that I am slow in doing this. I can't speak properly. I can't walk properly.
But it was
I have to-
examined, my lord.
I can't put up my thumb straight, and therefore my thumb is tilted towards 45%. So therefore, this is a disability. Please give me reservations. It will be endless.
But before issuing that certificate, there are some procedure, my lord.
But tell us, you see, somebody must have, you must have gone to a doctor. He must have diagnosed you with some disease.
Yes, there is a thorough procedure, my lord. The
Where-
examination.
Where is that?
Yes, my lord.
No,
My-
which doctor has given you a certificate? Let us see which.
My lord, kindly see the certificate has been issued under section 58, my lord, 57, 58. In Act, my lord, 2016 Act, but section 58, my lord. Procedure for certification. Any person with a specified disability may apply in such manner as may be prescribed by the central government to a certifying authority having jurisdiction for issuing a certificate of disability. On receipt of an application under subsection 1, the certifying authority
You are
shall.
reading where?
Section 58, madam.
58 of which act?
2016 Act. Section 58, madam. Shall assess the disability of the concerned person in accordance with the relevant guidelines notified under section 50, and shall after such assessment, as the case may be, the certificate shall be issued under this section shall be valid across the country. And then section 59 also, madam, appeal against a decision of certifying authority. Any person agree with decision of the certifying authority may appeal against such decisions within such time and in such manner as may be prescribed by the state government to such appellate authority as the state government may designate for the purpose. On receipt of the appeal, appellate authority shall decide the appeal in such manner as may be prescribed by the state government, madam. And these two authority has been notified by the state government, madam, Annexure 1, madam.
Okay, let me consider part of it. Yes, what do you have to say?
Lordship, this was examined, the petitioner was examined by the experts of GMCH, Lordship. Only after that, Lordship, this remark was, Lordship, this remark was given by
So
the.
now he's saying that, Mr. Roy is saying that even if there's no, he does not fall into a benchmark category, but he should be considered as one.
But Lordship, he appeared before the bench, Lordship, the medical board. He appeared before the medical board, Lordship.
Well, that board is yours, the statute, my lord. But I have challenged that board. My lord. The constitutional medical board, my lord, I have challenged here. My lord. There is no provision, sir. In earlier act, my lord, under rule, my lord, there was the power of the state government to constitute a state board. Therefore, my lord, the practice was there earlier. But in new act, my lord, there is no such state board. My lord.
State does not have a board.
No, under this act, my lord. In earlier act, my lord, there is a rule 4, my lord. State government has the power to constitute a board.
Then we will stop all the MSCT cases. You implement, you will convert this into a PIL and ask for the stay of all the MSCT cases, because in MSCT cases, we rely on a certificate by the doctors. So if you say that the medical disability right prevents that state board, so we'll ask the, yes, Mr. Rupania, why this state board should not be disbanded? And everybody should be asked to go to the central board.
And my lord, under this act, my lord, the state government has the power to make frame rule, my lord, within 6 months, my lord. They have not framed, my lord. Now, my lord, after 2 years, 3 years, my lord, they are issuing office OM, my lord, notification, my lord. They try to rewrite the act, my lord, this act, which is not permissible, my lord.
Where they have done it? Which document?
Lordship, page 60, Lordship, the OM, page 60.
60. This is something which we also do. There's a requirement in the act to identify posts where people can be accommodated or adjusted with a disability. So this notification of the government, we also have done it in the High Court, because there's a mandatory requirement. Every establishment must have a what you call under 2R benchmark disability. We'll have to identify posts. Because I ask you a very simple question. Let us say that you have a threat perception. Correct. Mr. Roy has a threat perception. You want a what you call PSO for you. And then the government sends to you a PSO who is blind. There's another PSO who is having hearing impairment. Because we have to give accommodation to this Disability Act. So therefore we appoint, under the order of the court, these benchmark disability people are appointed as police constables. And all these 4 people having benchmark disabilities are provided to you. Now tell us, would it serve its purpose? Will you give employment? If you have to give employment yourself, will you give employment to a person as a night guard who is blind?
Therefore, there is the.
No, if you say yes, we'll accommodate. We'll ask the state government to provide with you with people in your office as assistants, compelling you to do it, to adopt them.
My lord, therefore, there is a provision for the assessment of suitability of the.
That's why when you are pointing out page 60, I'm only responding to page 60.
Page 60, my lord, he pointed out, my lord.
No, 60, if it's not there, you said that they are rewriting. So where is that rewriting? It's not there. Okay, I'll examine and pass orders.
A similar case has been already, my lord, the issue herein, my lord, I have questioned the constitution of the special board, my lord. The same matter has been fixed on 14, my lord, also, my lord. The other matters,
Yes, 14.
14.6, my lord, my lord. Only your lordship has passed the similar. And there are other matter, item 22, 24, 25, and 26, my lord. There,
Just a moment, just a moment. Government advocate, Mr. Sirius Barua,
1 to 6.
1,
1 to 6.
6,
1 to 6.
1 to 6.
6 to state level.
6, you are appearing. Department of Social Justice, you are there, Mr. C. Sharma. So, Panyo, you are for
4, 7, and 8.
4, 7,
And 8, lordship.
8. 5 is forest.
5.
Your name?
M. Kalita, your
M. Kalita. 5, 6. This Okay. What was the word dyslexia?
Yes, lordship.
Yes, you have anything more to say, Mr. Panay? For this disability? Or
Lordship,
social,
yes,
social
lordship, we have-
welfare? Social welfare, you have to say anything in this disability issue?
Lordship, we have examined and we have found that this doesn't fall under any disability, lordship. And that's why that 59 was issued, lordship. That's right, lordship, this 58, page 58 was issued by the Environment and Forest Department, lordship.
58. Where is
From
that?
the, it was issued by the Personnel Department, lordship, to the Forest Department, lordship, based on our lordship findings, lordship.
Okay. Okay.
Obliged, lordship.
Item 18.
Item 18.
Lordship, I'm not on record, Lordship. I engaged to Mr. NCP has some personal difficulties, Lordship. So I'm paying for adjournment.
Okay, on the prayer, both sides are represented on the prayer made by counsel to the petitioner. List after a week.
After 2 weeks.
Okay.
Obliged lordship.
Item 20.
Back to the lordship. This matter regarding non-payment of pension to the retired master of worker. He was retired in the year 2000.
You should notice the matter.
May I prefer, because we have given terminal gratuity, we have given him, AG has given him terminal gratuity. Why it is not given? That is also because as per reported judgment, which was decided by honorable court, he is supposed to get it. But anyhow, may I prefer at least one time next year? At least instruction why it is been not. Maybe some region, let me verify for sense of justice. According to me also, he is entitled, but why it has been not given, we have to take instruction to that effect. Or lordship may fix on Friday.
Okay.
Friday?
Okay. Also is represented on the prayer made by Mr. C. Barwad on it.
Accountant General, that's now 4 mile.
Standing counsel for the accountant general, list on Friday.
Friday, obliged. Silent. It's copy দিব পাৰিবা?
21.
Yes, we're issuing notice. Mr. N1, learned counsel for the petitioner. The departmental proceeding against the petitioner issued by show cause notice dated 19/2/2021, which is continuing till date, is questioned in this petition filed under Article 226 of the Constitution of India. Issue notice, including notice on the prayer for interim relief, returnable. Give a date after 4 weeks, on so and so. Next, para.
M. Kalita, Your Lordship.
Miss M. Kalita.
Lordship.
Learned counsel for the Forest Department accepts notice on behalf of all the respondents. Requisite extra copies of the be furnished of the requisition we furnished to her in the course of the day. Next, list on so and so.
17th July.
Obliged, Your Lordship.
Item 22.
Yes.
Here is the, my lord, the petitioner has the hearing impairment, my lord, 60% permanent, my lord. He has been issued the certificate, my lord, page 39. And UDID, my lord, 41. But the report says she has, my lord, 13%. Page 57.
Page?
Page 57.
60?
57.
67.
57. So admittedly, my lord, even They have admitted that I am the disabled person. Only my lord, the percentage.
Okay, we issue notice then. Mr. S. K. Roy and counsel for the petitioner. The disability status of the petitioner. Communicated to the petitioner by letter dated 8/2/2024. Disclosing the percentage of disclosing that the petitioner is suffering from 13% disability during his this is appeal assessment.
Reassessment.
Re-examination is held in this writ petition filed under Article 226 of the Constitution of India. Issue notice, including notice on the prayer for interim relief returnable in same date, 4 weeks, returnable on so and so.
17/7.
My lord.
Requisite extra copies of the writ petition is on Mr. C.K.S. Barwar, and the government advocate, who accepts notice on behalf of
One and two.
respondent numbers 1 and 2. Mr. C. Barwar and C. Sharma and his standing counsel for respondent number 3, and Mr. D. Upamanya and a standing counsel for the Health Department representing respondent number 4. GAD who will be appearing? GAD, General Administration Department, who's appearing?
The lawsuit that কি নাম আছে এটা সৰু করে Orna Pukal lawsuit.
So Mr. A. Fukan, standing counsel for respondent number 5. Mr. V. Chaudhary, and standing counsel for respondent number 6. Karbi Anglong, Mr. Sukia, Mr. J. Vidyal, and standing counsel for the respondent number 7. Mr. Upamanya would be for 4 and 8.
It was us.
List on so and so.
Appearing for the respondent 5 lordship, we have not got received any copy lordship.
First time.
First time.
I will directly give me a copy.
Registry will reflect our name, madam.
Okay. The registry shall reveal the name of the State and Departmental Council while listening the matter next. Okay.
Awesome.
My lord, one problem, my lord, can you see paragraph 27, my lord?
27.
Paragraph 27.
But what is the date? 8/5/2024. For the petitioner for appointment, if successful in establishing his benchmark disability, shall be subject to further orders that may be passed in the writ petition.
Twenty-three.
May it please your lordship.
Yes, Mr. Patori.
My lord, this case is fairly covered by a coordinate bench decision. What happened, my lord? The petitioner was a employee under a PDCL and she retired from service on 31/3/2016.
We'll issue a notice here at this stage. We're issuing a notice here at this stage.
Lordship, perhaps notice may not be, I'll leave it to your lordship. We have decided to, since there are lots of claims similar to the petitioner, people who have retired on 31st of March and whose pension should be revised with effect from that date. So we have taken a decision, your lordship, to give that benefit to everybody. So the petitioner will perhaps be covered by this decision. But the only liberty that we are seeking from the honorable court, because in the other orders, a fixed time frame was fixed for paying the area benefits. Now, because of the huge number of claims involved, your lordship, we are saying that we may be allowed to pay the area in 5 installments across 2 years, your lordship. And the revision will do it right now and will pay the petitioner the revised pension with effect from today, but the
2 financial years.
yes, but the area, your lordship, we may be allowed to pay in 5 installments across 2 years.
Yes, they have given an undertaking.
Yes, I can
Yeah.
share this with my lordship.
If they are financial crunch, we can't.
But
But there is a order of this honorable, anyway, my lord, I leave it to this honorable court, my lord.
and in
They have
that
preferred-
matter also, we have filed a review, your lordship.
No, my lord, the original decision.
No, they are saying that for nine people, the backlog is 21 crores. If there are any others, there will be a huge amount of demand. So unless the government gives them money,
The money comes out from a pension fund, your lordship. If so much money is extracted at once, your lordship, then it will be a little difficult to meet the future like.
no, what we do is that in view of this,
Lordship.
if you don't pass a judicial order, we say that you will take a decision and communicate it to the petitioner within 1 month from today.
In terms of this order, your lordship.
No, his claim will be considered whether this here or
Very
there.
well. Very
We record your statement.
Yes,
that,
very
you are in view of the writ appeal, you have, you will consider what you call examination of the case of the petitioner. And within 1 month, you communicate to him.
Lordship may indicate this decision taken in this meeting, your lordship, because this is my instruction. We'll take a decision.
Okay. Heard Mr. J. Patwari, run counsel for the petitioner. As well as Mr. K P Patak, analyst standing counsel for the APDCL,
Respond numbers 1, 2, and 5.
1, 2, and 5, and Ms. M. Fukan, done
K Fukan, your lordship.
K. Fukan, done standing counsel for respond number 2.
3 and 4. 3
Okay,
and 4. your
3 and 4. Okay,
Page is there.
3 and 4. Next, madam. The case of the petitioner is that he retired from service.
See, my
as-
lord.
Huh?
See, petitioner is a lady.
Okay, the petitioner that she has retired from service as accounts officer, Jorhat in the APDCL, electrical division dash Roman 2. No, you say accounts officer Jorhat electrical division dash Roman 2, APDCL. Full stop. The first of on retirement, the petitioner was paid retirement benefits in terms of ROP rules, 2010. First of, however, the petitioner claims that she later on came to know that he is entitled to a higher pension in terms of ASB revised pay rules, 2017, which had been given retrospective effect from 1/4/2016. Therefore, the petitioner claims that she would be entitled to revision of her last pay drawn on 31/3/2016 as per Rule 4 within bracket A of the ACB revised pay rules, 2017. Full stop. Next paragraph. The petitioner claims that without revising her last pay, the respondent authorities have revised her pension by applying Rule 32 of the ROP rules, 2017. And therefore, the petitioner has filed this writ petition under Article 226 of the Constitution of India, seeking appropriate directions for revision of a pay in terms of the last pay drawn, which would be her pay as on 31/3/2016. Next paragraph. At the outset, the learned standing counsel for the APDCL has produced a copy of the minutes of the JCC meeting held on 27/2/2024, and it is projected that that in the said meeting, decision in principle has been taken to provide the benefit of revised pay scale as per ACB revised pay rules, 2017. And in this regard, he has produced a copy of the said minutes. Next paragraph. It is submitted that although the petitioner is relying on the judgment of the division bench of this court in WA 107 of 2023, wherein order dated 22/3/2023 was passed, right? 22/2/2023, the writ appeal order.
Yes.
My lord, it's annexed in the writ petition.
20
Annexed,
23.
at
It's
this-
okay, and just on the date is correct.
Yes, sir.
That is correct. It's annexed.
So it is submitted that as per his instructions, the respondent authorities have filed a review application against the said. You said you review, you filed a review.
Not against this order, Your Lordship. There was another order passed in the matter filed by APDCL also. In that we have filed the review. That Lordship may not record that, Your Lordship.
Okay. Full stop, no? Full stop. Accordingly, it is submitted that as per his instructions, the ACB, the respondent authorities would consider the claim of the petitioner in terms of the ROP 2007, 2017. Stop. He is further submitted upon instructions that the respondent number 1 is only seeking liberty from the court to disburse the arrear benefit which may accrue to the petitioner within in 5 installments spread over a span of 2 financial years. So, however, he submits that the decision on the entitlement of the petitioner to the revised pay scale would be taken within a period of
1 month.
within a period of 1 month from the date of producing the certified copy of this order. Next paragraph. In view of the statement made at the bar by the learned standing person for the APDCL, the court is inclined to dispose of the writ petition at the motion stage by providing that the competent authorities in the APDCL shall take a decision on the claim of the petitioner on his claim for on her claim for benefit of revised pay scale as per ASB revised pay rules, 2017. By considering the entitlement of the petitioner as per her last pay drawn on 31/3/2016. Of her last revised pay. Make it
Under
last
Rule
revised
4A.
pay. The revised pay. No, revised pay will cover 4A because I have stated that. Full stop. Next part, it is also provided that while disposing of the claim of the petitioner, it would be open to the respondents to give an undertaking to the petitioner of the time span in which they would disperse the arrear payment due to the petitioner. However, no order is passed to that effect. Full stop. Next paragraph. As the matter has been disposed of at the motion stage, liberty is granted to the petitioner to approach the court if he still agrees.
May I, with another thing we recorded, in the order passed by the division bench, the respondents, which were the petitioners in the writ petition, they were directed to give an undertaking that in case they do not succeed, in case the APDCL, my sister organization is successful in that appeal, they will give an undertaking that they will refund the amounts already paid to them. Such undertaking may be provided with the petitioner also.
Yes.
No, you can pass such any order because that will be covered, because otherwise I had to take cognizance of everything, then record it.
Otherwise, if my learned friend gives that concession,
They will claim, I'll give my note. Others have also.
that may be that undertaking that because otherwise, because the division bench matter is still pending.
Will give my note.
If that can be recorded.
Just add one line that you may on such terms, that word be added, huh? Dispose of the representation on such terms as.
My letter will be.
Because there are things which may complicate. Without
I
understanding the Connotations, what one line will do, we don't know.
Deeply obliged.
Deeply obliged, my lord.
Dispose of, let the motion stand. 24. Yes.
Same line. My lord. 56 the report, my lord.
Hmm?
Report, my lord, at 56.
56.
Yeah. It is given 10.94. Hearing impairment.
Okay, yeah, same as item number, last item was, item number,
22.
last one, item 22, same. Here the disability is 10.94%. Hearing impaired. Page 56. Same set of counsel for the respondents.
No, same.
Same, Your Lordship. And for respondent number 6, Your Lordship.
Your name?
H. Rampi. H. Rampi.
HK, H. Rampi. Learned counsel for respondent number,
Respondent number 6.
respondent number 6. Only that is the change.
No, Lordship, earlier one, that was Karbi Anglong, Lordship, now it is Baksa, that is BTC.
BTC. BTC will be there.
Ita Borobra, the name.
Huh?
Joint director has been already.
P
other
nine.
cases,
Huh?
For BTC P9.
P9, okay, P9 BTC. Respondent number 6.
7.
Respondent number 7. Okay,
Become the number.
just check up.
No, Lordship, 7.
7.
And
Seven.
Lordship, in this matter, Lordship, I am appearing for 4 and 8, not 7. 7 is P9.
No, just say 1 and 2 is.
One is myself.
1 and 2, Mr. C.K.S. Barua. Number 3,
Yeah.
Mr. C. Sharma. 3.
4 and 8, Lordship, I am appearing.
4 and 8, Mr. D. Upanan.
5, Lordship, B Chaudhary.
5 is B. Chaudhary.
6, I'm appearing, Your Lordship.
6, Mr. Rampi.
And 7 is P9.
7 is Mr. P9. Okay, same one.
And Lordships, other matters are also.
25, 26, you can put it.
This is 25, 26 are all same.
25, 26 same.
Yes, Lordship.
Here, what is the disability? Just write in a piece of paper and give it to my court master.
Right.
Page 56, that disability.
Yes.
Write and give it to the court master.
Petition. Yes.
For which, just indicates, give it to the court master. Yes, must be go paper.
May please.
Upgraded item 54.
May please. Lord, petitioners, my lord. The petitioners were appointed as ranger, my lord. In the year 89-91 batch, my lord.
Yes, my lord. I have a report, my lord. There is a regular inquiry, my lord. They try to distinguish that it is only preliminary, my lord.
No, I can't put it, but I'll satisfy your lordship, regular inquiry.
Lordship, there's a table. Second page, my lord, will find the name of the petitioner at serial number serial 3.
3 and
4.
Oh, side.
Admitted position that regular inquiry is pending. I am not denying.
2014, 10 years.
Yes. Yes, my lord. Yes.
I can answer my lord right now.
Well, let me submit the fact, my lord. 2 lines fact, my lord. Your lordship, kindly have a look at page 17, my lord. Has your lordship got it? Page 17. 17. Hello, has your lordship got it? This is the notice issued to us, my lord, for regular inquiry by the vigilance, my lord. May I read it, my lord? This was in 2015, 18/12, 2015, my lord. With reference to the subject stated above, I am directed to inform you that above noted regular inquiry has been initiated against so and so, so and so, so and so, my lord. The petitioner's names were there. For a change at this at the instance in this directory, in the instance of the gov letter, dated so and so. It's a regular inquiry, my lord. What the document were called for and closed there, my lord. Has your lordship got it?
Yes.
This is the regular inquiry, my lord. This is the regular inquiry. They asked us to submit document. We submitted the document. Thereafter, your lordship will, very funny thing, page 19, my lord. Page 19. Has your lordship got it? 26 February 2021, my lord. Am I right? My lord, serial number 3 and 4 petitioners, they were promoted from the ranger to the assistant conservator of forest. There is a regular inquiry pending, my lord. And this time to assistant conservator of forest to deputy conservator of forest, my lord, shield cover, because regular inquiry of 2015. Now under the law, my lord, three essential, I am coming to the judgment also, three essential requirements is required for keeping the shield cover. One is the employee must be under suspension. First, either charge sheet issued to the delinquent or charge memo submitted to the court. In the present case, your admitted position, there was none. These the three essential ingredients required, my lord. Admittedly, they are also regular inquiry. That regular inquiry of 2015. And the same point was raised before the Supreme Court, my lord, in 1991, my lord. That so many irregularities are there. Supreme Court, so this is the preliminary, this investigation will continue. That doesn't mean that it will, that your lordship, I have relied on judgment, my lord, Binod Kumar Payeng. Last time I submitted it before your lordship. 2556 of 2019, my lord. Has your lordship got
We
it?
have one Devajit Das.
Another one is there, my lord. So I am supplying it. It will be there.
Binod Kumar Payeng, yes, it's available. No, you with the Supreme Court judgment.
Yes, you know that the 1991 4 SCC 409. That was relied and quoted in the Devajit Das case.
Janki Raman.
In the Devajit, why I mean Payeng Mayor, because that also case in the promotion from assistant conservator to deputy conservator of forest. That case. And that case below the preliminary investigation of vigilance is there. If your lordship turn to paragraph page paragraph 8 of the Devajit Payeng Milord case, my lord. Binod Payeng, my lord, your lordship, paragraph 8 quoted the judgment of the Honorable Supreme Court, my lord. Has your lordship got it? If your lordship keep the 1, 2, 3, 4, 5th line, my lord, right side, my lord, this seal. Has your lordship got it? The seal cover procedure is to be resorted to only after the charge memo or charge sheet is issued. Dependency of preliminary investigation prior to that state will not be sufficient.
Mr. Gopal, please, you may not read, because this is raised before us a lot of times.
No, Milord, this is the cover. The similar order was disposed of on the same line. They are also regular inquiry in case of chief engineer to promotion to the promotion, Milord. They were the Das case, Milord. In this case, Milord, Supreme Court already cleared it. Either this, that is why, Milord, in the deposit Payeng case, Milord, Vinod Payeng case, court held that paragraph 10 initiated by the vigilant ought not to be ground not to consider the case of the petitioner for promotion to the post of deputy conservator or for adopting the seal cover. Seal cover procedure can be invoked only when any formal departmental inquiry or any criminal proceeding is pending against the petitioner. It is admitted position, Milord. They also admitted no such sheet was submitted in the criminal case, no departmental proceeding, no suspension, Milord. The Supreme Court held that these are the three requirements, essential requirements. In the deposit Das case, Milord, your Lordship will find that is the RE, regular inquiry, Milord. It's a very short order, Milord, dispose of the petition, Milord. The second page, Milord, paragraph 2. The petitioner is presently holding the post of additional chief engineer to the department in the Department of Public Works by notification dated demand issued by the special commissioner to the government of the gradation license. So I'm skipping over. It is the case of the petitioner that the person below was promoted. Paragraph 3. The case of the petitioner before is that his case should be considered for promotion to the post of chief engineer in as much there are 5 vacancies available. The further case of the petitioner is that the regular inquiry is pending against the petitioner. However, till that no charge sheet has been issued, has been filed. Then the 5th paragraph regarding submission made by the land and PWD, the court is a considered opinion that there is no further impediment on the part of the respondent to consider the case of the petition. Well, until and unless, Milord, they cannot, if they fail to satisfy that charge sheet in a departmental proceeding or charge memo in a criminal case was submitted, no scope of keeping a person in the promotion in seal cover. That's also Supreme Court held that injustice caused to the employee in the 91 judgment, Milord. And therefore, my humble submission that it is covered by, because these 3 essential ingredients are absent in this case.
Yes. Under the Janki Raman judgment, he has been relying, madam. This honorable court has also interpreted in some other terms that once there is a criminal case, madam, which is a regular criminal case, madam. So the seal cover has to be given effect to, madam, to its full. And if it's found entitled, madam, there are also provision for supernumerary post. In his case, a post has been kept trinket. Madam, today I'm a bit handicapped, Lordship takes it up. I can argue this matter. The problem is, I face with I have taken instructions, the para-wise comments are under preparation, they are drafting. It requires some time also, if this is the law point he is arguing, other point, there is nothing to be prejudiced about because,
Definitely in a case, the counsel will only argue the legal points.
Look,
the Vinod Payeng is totally
I all admit it, Milord, let them satisfy the court whether I am in suspension, whether any departmental charge sheet was issued or any criminal case charge sheet was issued, submitted or not. These 3 requirements, if these 3 are not there, Milord, the suspension seal cover procedure cannot be adopted.
When is your retirement due?
2 years,
2 years.
2 years.
The post has been kept vacant, It's not
The
that
post vacant is not
People would be interested in having sitting in that post, not to keep it vacant.
The Janki Raman, that other aspect I would like to argue, This court has held, my lord,
Janki
and again, my lord.
Janki Raman, what is more there to argue?
But Janki Raman, this honorable court, my lord, I came across a judgment, my lords, that when it's given effect to, my lord, we'll wait till the proceedings are over, my lords. And if it is found entitled, my lords,
What is the proceeding? Tell us only that.
my lords, the seal cover is there, my lord, portion gave vacant.
What is the proceeding?
My lord, the criminal proceedings, my lord, I have indicated, my lord, that's a regular inquiry. Last date, my lord, there was a discussion, my lords. I had pointed out in Binod Payang, my lord, it's factually different. It's a preliminary inquiry.
You see, you come to your, what you call this, your EFR or any other, what you call, service law
Yes, my lord.
relating to disciplinary appeal and
My lord.
disciplinary appeal rules, Assam service the disciplinary appeal rules.
Yes,
Where do you find this preliminary inquiry?
my lords.
In which of these two laws
My lords.
you find preliminary inquiry?
I am well honest, my lord, I don't think there's a term, my lords. Some,
Is being found. Now,
no, my lord,
under CRPC, do you find the what you call abbreviation or the words defined as preliminary inquiry? CRPC.
right now, my lord, I'm I have to look into this, my lords.
Yes, preliminary inquiry you will find only in the
Look, my
CBI,
difficulty, my lord, I'm not denying anything.
in the CBI manual only.
He might have a good case, my lord, but without the absence of this affidavit, my lords.
If you don't find it, what can be done?
My lord, I'm filing, my lord, my lord will repeat one thing, my lord. Time and again, when it has come, when it is, time and again it has come, we are always prepared with instructions, everything. And my lord, this lordship is aware, my lord, these proceedings take some time, my lords.
2015 onward, they are taking
No,
time.
no, 15, I'm not
Yes.
speaking about 15, my lord.
10
I'm
years
saying
is-
about this 2024 matter, my lord. It's a 24 matter.
Okay. We give you till 2 weeks time to file it.
Yes, man,
This
that can
notice
be
was
done, my
issued
lords. Without
on
affidavit,
6/3.
my lord, I find difficult to concede, my lords.
No, because if we say that if you don't file it, then we take it.
No,
to
we'll
CC.
file, my lords. But
Mr.
my lord,
Gogoi,
my lords,
your officers are not giving him the competent authorities who have to take a decision on promotion.
my lords,
They are the persons who will give you instructions.
my lords. No, my lord, I had asked them for the formal parawise reply, so I could draft a affidavit. My lord, they are under preparation, my lords.
2 weeks time
Yes,
to
my
file
lord, 2 weeks,
affidavit.
2 weeks, my
uh, Heard Mr. S. Kotakil and counsel for the petitioner on the prayer made by Mr. D. Gogoi, Leonard, standing counsel for the forest department. One last chance is granted to the respondents to file their affidavit in opposition within after 2 weeks. What will be the date?
19, my lord. 19 June.
By 19/6/2024, list on 21/6/2024.
My lord.
My lord, it's fail to file the affidavit, my lord.
Okay, one last chance we have said. That's all.
Otherwise,
How does, my lords?
So you do it. This is only a
Well,
last
we'll do it.
chance.
We'll do it. This is under preparation.
Your instructions here,
Well, make keep it also.
not required. This will be. When you're filing an affidavit, you can bring it on record.
My lords, then I can take it. Does that conclude? Hold it.
Item 27.
my lord, short issue, my lord, the petitioner who is the sanitary inspector of my lord Nalbari Municipal Board, he was put under suspension in November 2015. And till date, my lord, he is in that status, my lord, without any, my lord, proceeding or even a show.
Okay, notice was not issued this first time.
First time. My lord.
Okay.
Only prayer, my lord, from February 2022, the substitution allowance had been stopped. So from February 2022.
22.
Yes. So current, my lord, some allowance may be, my lord, given from this month. My lord. That's the intent.
But Mr. B. Govil and counsel for the petitioner.
It is a page
The-
18, ma'am.
The continued suspension of the petitioner since 27/11/2015 is held in this writ petition filed under Article 226 of the Constitution of India. The learned counsel for the petitioner submits that the petitioner is not been paid subsistence allowance since February 2022. Next one. Issue notice returnable on, give a date after 4 weeks. Returnable on so and so.
And for one and two,
uh,
Lordship.
Ms. K. Talukdar and Government Advocate accepts notice on behalf of respondent number
1 and 2, Lordship.
1 and 2. Requisite extra copies of the writ petition be served on her in course of the day. Next para. The petitioner shall take steps within 2 days for service of notice on the respondent numbers 3 to 6. No, you will be for 1, 2, and 6.
6.
6 is Deputy Commissioner, 1, 2, and 6. 2,
Lordship.
3, 4, and 5
Lordship.
by registered post with ED. And in the learned counsel for the petitioner shall collect the posted receipt number and shall submit posted track report prior to the next date of listing. Next para, in addition, the petitioner shall serve notice on the respondent number. Yes, why there is 4 and 5 both? If there is a chairman, there can't be an executive officer.
In fact, my lord, this order has been issued by the executive officer.
You have a chairman or you don't have a chairman now?
It's there, man, it's there.
Huh?
He is there.
If he's there, then 5 will not be there.
My lord, I leave it to your lordship. But the impugn order has been issued by the executive officer at that point of time.
So on the respondent number 3 and 4, by way of Dasti, by routing the process to the registry of the court and upon service and affidavit of service shall be filed prior to the next date of listing. Next para. As the issue relating to continued suspension is already well settled, comma, the respondents are directed to file their affidavit in opposition positively 1 day prior to the next date of listing. Next color. The pendency of the writ petition shall not be a bar for the respondent number 3, i.e. the Nalbari Municipal Board, comma, represented by its chairman, to disburse the aerial and current substances allowance to the petitioner with effect from February 2022 till date and inform the court on the next date about the status of payment of the subsistence allowance. Next para, list on.
Lordship. Obliged, ma'am.
Obliged, Lordship.
28.
May I please as a lordship?
Yes.
Lord, the matter relates to, my lord, computation and family pension, as well as the other consequential benefits, my lord, which the petitioner is entitled to
as the Milord,
Is there any family dispute
Milord,
between
there
two widows?
Milord, two widows are there. One myself, Milord, and another one is there. Milord. Now, as per the
Is,
compassion of-
is there any dispute between you two?
No, no, Milord. At this moment, dispute means, Milord, the second wife, that is the respondent number 10, is now, Milord, is now an attempt is going on to bypass me and, Milord, to siphon the entire benefit in her name, Milord.
That means there is a dispute.
My lord. So, my lord, at this moment, my lord, that if the amount is being paid to the private respondent number 10, my lord, that is not admissible under the, my
Where is the
lord.
document to show your marriage?
Yes, yes, my lord, we have annexed the Kabin Nama, my lord.
Where is that?
My lord, may be pleased to find the annexure 1, my lord. So that page 34, annexure 1, my lord, is the marriage Kabin Nama issued by the, my lord, Northeast India Emirates Shariat. This is a, my lord, procedure adopted by the Qazis, my lord. We issue this Kabin Nama, my lord. And herein at page 34, my lord, the bridegroom's name, my husband name is there, my lord, serial number 1. And, my lord, my name is at serial number 2, my lord, as a bride's name, my lord. This is a document of 9/6/1992, my lord. We have also annexed the vernacular part, my lord, which is also at page 36.
Vernacular has some corrections
My lord.
in the signatures. Why?
My lord, as it had been provided to us in the same manner, my lord. My lord, there is no dispute that I am the first wife, my lord.
Okay, you are issuing notice then.
My lord. My lord, only my limited interim prayer, my lord, that the amounts, my lord, which due may not be released, my lord, without adjudicating the matter, my lord. Even, my lord, I am, even lordship, my lord can pass an order not to release in my favor also, my lord, first and second wife, although I am entitled, my lord. My lordship is well aware, my lord, the full bench of our
No,
honor.
if you are two wives,
My lord.
she'll be entitled to 50%. Why can you stop that?
No, my lord, the full bench of our honorable court, my lord, has decided recently, my lord. My lordship is also come to the judgment, my lord. In Jonufa baby's case, my lord. Respect of, my lord, Mohammedan wives, my lord, that the personal law will govern. But in paragraph 21, my lord, at page 10, 21 and 22 is relevant.
Still, it can be divided by the court by a judicial order.
My lord, in
This disbursement will not be considered as estimate bar on such separate payment.
my lord, in para 23, my lord, if the government.
We are reading 23 only.
Yes, yes, my lord, in paragraph 21 and 22, my lord, this honorable court has held that should be given to the eldest surviving widow, my lord. Now, my lord, rule 143 has also been taken care of. Note 1, my lord, I have also quoted that part, my lord, may be pleased to find, my lord, at page 16 of my writ petition, my lord. That is note 1, my lord, whole manner, my lord, in case where there are 2 or more widows, pension will be payable to the eldest surviving widow. On her death, it will be payable to the next surviving widow, if any. The term eldest would mean seniority with reference to the date of marriage. Now, my lord, I being the senior, my lord, eldest, I am entitled, my lord. But, my lord, if in the meantime, this private respondent number 10 is succeeded to, my lord, get the benefit, my lord, then the purpose would be defeated, my lord. That's why I am on an interim. Let her come, my lord, before this honorable court, my lord, to establish her right. Till then, my lord, no amount should be released by the authorities, my lord.
But Mr. A.R. Bhunyad, I'm counsel for the petitioner. So, also heard. Oh,
Lordship, I'm on behalf of Duke Mandir.
for respondent number 1.
1, 4, 5, and 6, Lordship.
1, 4, 5, and 6, Mr.
My name is M. Bhuya, Lordship.
M. Bhuyan, and counsel appearing on behalf of
Duke Mandir.
Mr. D. Upamanya, counsel for standing counsel for respondent number 1,
4, 5, and 6.
4, 5, and 6. And Ms. A. Talukar and the government advocate appearing for respondent number
3 and 7, Lordship, pension
3
department.
and 7.
Lordship.
Lordship, the finance department is also a party in this, respondent number 2. In this case, Council B. Gogoi's name may be recorded.
Finance, okay. Mr. B. Gowai, standing counsel for respondent number 2. And pension,
Lordship, 3 and 7, Lordship.
3 and 7, you are there, okay. Giving entitlement to the family pension as first wife of the deceased government servant, namely, what is the name of the husband?
My lord, Tazimbar Hussain, Tazimber.
Tazimbar, Tazimber Hussain,
My lord.
who
Died
at
on
the time of death was serving as
My lord, as a pharmacist
a
under the
pharmacist.
Joint Director of Health Services, Bongaigaon.
Joint Director of Health Services, Bongaigaon.
My lord.
The present writ petition has been filed under Article 226 of the Constitution of India, claiming prior right over respondent number 10, who is the second wife, projecting her to be second wife. Issue notice returnable on so and so after 5 weeks.
What?
So requisite extra copies of the petition is served on the Rwanda State and Departmental Council appearing for respondent numbers 1 to 7. As per the petition shall take steps within 2 days for service of notice on the respondent numbers 8, 9, and 10 by registered post with AD. Next part. Learned counsel for the petition shall collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next part. Till further orders, the who will be the disbursing authority for this pension?
Not
Mr.
the
Upamanya?
Joint Lordship. The Joint Director of Health Services, Bongaigaon, my lord. Respondent 5, my lord.
From the Treasury Office of the Bongaigaon district.
The
Disbursing.
the Joint Director of Health Services, Bangagaon, within bracket respondent number 5, shall issue necessary instructions to the competent authorities not to disburse the family pension
There is other
of the
and also other benefits.
another another benefits like death cum gratuity
GIS.
and
GIS is also there. Group insurance,
GIS,
GPF.
GPS, etc. Of late Tazimbar Hussain was last working as pharmacist in the pharmacist under the Joint Director of Health Services, Bongaigaon. Till further orders. I think for the disbursed. Next, paragraph, the petitioner shall produce a certified copy of the order before the respondent number 5, bring the order to the notice of the said authority.
Obliged, highly obliged.
Twenty-nine.
24.
May I please, Your Worship? My lord, here, my lord, the petitioner's, my lord, salary has been, my lord,
Salary.
stopped.
Okay.
Since,
Notice.
my lord,
We issue notice that Mr. M. Mandal and the counsel for the petitioner and Ms. A. Talukar and the government advocate appearing for respondent numbers
1, 2, 3, 4, and 6, Lordship.
1, 2, 3, 4, and 6. One, two, three, 4, and 6. So 5 accountant general, we are there. Miss
A Sharma.
A. Sharma, standing counsel for respondent number 5. And treasury officer is finance.
Finance, Lordship.
Finance, Mr. B. Govey was there.
Go.
And Mr. B. Govey, the standing counsel for the finance department, is present with performance 7. That's fine. The petitioner projects that. Where is this 29/9/23?
my lord, page 22, my lord,
20?
page 22. Lordship will find, my lord,
Annexure 6.
page 23, that is the, my lord, operative part, page 23. And regarding present petitioner, Lordship will find first paragraph, last 3 line, my lord. Similarly, Fatima Khatun, so and so, newly nomenclated number 10, Holongapara, Lordship got it. Last 3 line of the first paragraph, page 23.
Since April 2023 to till date, salary has been more or less stopped.
ঠিক আছে এবার এই ফাইলের মধ্যে এগুলো নাম্বারও থাকে নাম্বারও তুমি নিজের সাইডে নো ফাইলটি ডিলিট করলে নো ক্লিক করবে এই মানে ফর্মুলার ফাইলে জাভাস্ক্রিপ্ট মানে স্ক্রিপ্ট বা কিবা তাতে ব্যবহার করবে এসকিউএল এসে তেমন করতে না তেমন
This is a letter which can't be quashed. You are paying for quashing of 29.9.
My lord.
29.9 is nothing. It can't be quashed.
My lord,
What
page
is- what is there to-
23,
What is there to quash in this 29.9?
yes.
What is there to quash?
By this, my lord, the salary of the petitioner has been stopped, my lord.
Please read it.
Yes.
Where do you find that?
Page 23.
Please
Last,
read.
yes. That sir, pursuant to the order of so and so, letter number so and so. It was 16/3/2023, along with the honorarium of the Fatima Khatun, so and so Holongapara, the honorarium of Sahara Khatun, so and so 8 number Chaudhary Chowk, Anganwadi worker, has also stopped till further order.
You are satisfied that what you are reading is correct?
Now, salary has been stopped.
No, the officer is saying that because of that order, it has been stopped, and next line is that I request you to look into the matter.
Yes.
Now, this is something you are asked for quashing.
Now, facts remain that they are not getting
No,
the
but
salary.
this is nothing to be quashed. We don't find anything. We dismiss your petition, Mr. Mandal.
Now, since salary has not been paid,
I don't know. That salary part I understand, but you are asking for quashment of 29.9. This is only a communication. He is writing to the superior authority that by this order, your salary is stopped. So
Yes.
do the needful.
yes.
And you want this to be quashed.
And now they have said, "Lord, because of this, Lord, our salary has been stopped."
You know that better.
Yes.
At least more better than me. You know English more better than me.
Now, ultimately, Lord, their salary has
No,
been
but
stopped.
the salary is different thing, but you have asked for quashing. You remove this pair. We issue
Yes,
notice.
that prayer, Lord, will, Lord, would do, Lord. So, but mandamus portion is there, Lord, that maybe.
Mr. M. Mandal and counsel for the petitioner. Has submitted that I aspirate that he may be permitted to delete the prayer made for quashing of the impugn order, letter dated 29/9/2023 within bracket annexure 6. Post the prayer is allowed. The said part of the prayer is permitted to be struck off under the hand and signature of the learned counsel for the petitioner. Next paragraph. The next, filing this declaration in Article 226 of the Constitution of India, the petitioner has prayed for releasing her salary with effect from 1/4/2023 to 31/5/2024, as well as the current salary. First off, the petitioner claims to be serving as, in what capacity you are there?
Anganwadi worker.
As Anganwadi worker in number 10, Holongapara, HOLONGAPARA, AWC. Not salaries, make it honorarium. Explanation notice. returnable on so and so after 5 weeks. Requisite extra copies of the requisition be served on the runner state and departmental council within 2 days. Next, the contention of the requisition shall not be a bar for the respondent authorities to examine the claim of the petitioner and to release her salary if found due.
Developers.
You strike out.
Yes. my lord.
Item 30.
My lord, similar case, my lord, Lordship will find same report.
Here also same thing has to be struck out.
Yes, sir.
Acha. Here would be appearing for respondent, just look at the hospital. and tell
Yes,
us.
Lordship.
Uh,
1, 2, 3, 4, 6. 1, 2, 3, 4, and 6.
You are appearing. This is any, what is it? Just a D message for respondent number 5. Anybody else? Treasury, Mr. B. Gogoi, respondent number, treasury is
7.
7. Same thing, you strike it off.
Well. Developer.
Lords,
Yes,
I'm challenging the order in extra 7, your lordship.
before you challenge your order, you have to go and, what you call, take classes of your clerk. Yes, your clerk has downgraded you. This will also show you that I read everything.
Lord,
Yes,
your lordship, the appointment of the Gaon Pradhan at Nalbai district, issue notice, your lordship. In the meantime, if lordship permit, one post may be remain vacant as an interim term. As per the advertisement, the respondent notary has selected some private respondent.
but selection is already, we can't keep it vacant once he is selected. It
The
can't be
selection
made
is
vacant.
process.
And alternative remedy is also there, Lordship. Now,
Having appeal.
yes,
constant appeal.
Lordship.
But it's not functioning, your authority is sleeping over the matter.
Lordship.
He does not want to work. At one point of time, we think that we'll ask the chief secretary to take it up.
No, Lordship, now the matters are being taken up, Lordship.
No. At least in these 2 weeks, something has happened, we don't know. But for last 2 years back, 2 weeks back, we had issued strictures against your officer.
We have communicated this order.
What has happened, but
They are saying that
we are still not
taking
working.
up totally, lordship.
It's still not working. At least 1,000 judges are there online in the YouTube. He can just see any video from this court or from Bombay, Calcutta, Delhi, wherever he wants, and learn how to adjudicate. If it doesn't want to work, we don't appoint a person. Everybody is complaining. There are at least last 2 weeks I was not there. Before these 2 weeks, I had taken up almost 5, 6 writ petitions in a week, saying that your DLRR is not working, is not taking up adjudication. Files are not moved, the appeals file are not even registered. The records of various district commissioners, what do you call this? The 3 divisions, they are not called. You don't even, the officer does not even know how many appeals are filed.
Lordship.
So you create an authority and have it manned by an officer who does not work. Can you give the gentleman a call, phone call and tell us in 10, 20 minutes, half an hour?
Lordship
Because-
Appellate Authority.
Yes, if
Yes.
he does not want to work, we direct the chief secretary.
I'll call you.
After some time.
Yes, Lordship.
Thirty-two.
May I please, your lordship? Lordship, in this petition, I'm challenging the report of the medical board. Actually, your lordship, I am a person with benchmark disability and I applied for a post. Advertisement was floated by the respondent authorities, but by appointment was, I was not appointed because
Where
this
is your medical report?
lordship medical report is at page number. It starts from page number 64. This test I performed after they rejected me.
64.
It starts at page number 64. This is a report. The test is dated 16/11/2023. Your lordship may kindly come to page number 68.
64.
Starts at page 64. Your lordship may kindly come to page 68. They don't give a report as such in writing, but from here we need to interpret the capacity of hearing of the patient. Lordship has taken page 68.
Yes, after that, the High Court order, where is that medical report?
The impugned report, your lordship.
Yes.
Your lordship, the impugned report is at page number 100. Annexure 28. And I appear at serial number 218 on the next page, page number 101. Last page of the writ petition, your lordship. Page number 101.
Yes, what is your name?
My name is Kaushik Das at serial number 218. Your lordship, fifth from below. Kaushik Das, hearing impaired, 23%.
You've done any audio tests?
Your lordship, Bera test was done, your lordship.
Where is that?
That is page 64 is the about the Bera test, your lordship. Page 64, that is the Bera test. Starts from page 64 and the operative page will be page 68. Is the scientific graphical outcome of the report of the test.
What basis you say that there is an error by a medical board in examining your audio disability? What is the ground?
Your Lordship, the Bera test takes around 45 minutes. But I was done the test for only 5 to 10 minutes. Within that time, my test was finished. So I say that the test was not perfectly done. And after the report of the medical board, I did this test. That is at page 64. Same in GMC. And therein it is coming that my disability is 57%, 57.1 to be precise.
Okay, we should notice then. Where is your statement that your test was? What do you, when you read question, how do you say how your test was done?
Lordship, your Lordship may kindly take para number 5 of my petition, your Lordship, at page 10. And on the next page was the last portion of the paragraph. May I read it, your Lordship?
Okay, I get it, got it.
Yes, your Lordship.
Heard, Mr.
Mr. A. Khan.
A. Khan, the counsel for the petitioner. Yes. I'm Patasaryan and government advocate appearing for respondent number 1.
1 and 2, Lordship.
1 and 2. Mr. V. Chaudhary and it's standing counsel for respondent number 3. 3 and 4. For medical education, Mr. Upamanya. Mr. D. Upamanya and standing counsel for the health department presenting respondent numbers 5, 6, 7, 5 and 6. 7 is social justice.
7, 8, 9, I'm appearing.
7 at 9, Mr. C. Sharma. Cooperative society. Cooperative society.
Yes, MD Bora. MD Bora is there, Lordship. SC Cooperation. MD Bora, Lordship.
MT Bora. MT Bora is for respondent number 11.
12 is unknown, Lordship. Principal
12 is unknown.
Secretary.
We can't issue notice on
Yes,
12.
Lordship, of which department not?
Sorry.
It will.
13 also is health. Mr. Upamanya. Next, the petitioner shall take note of the incomplete cost title of respondent number 12 and take appropriate steps. to amend the cost title, which shall be done in the presence of AOJ, civil rule pending, and the concerned official on correction being made shall ask the learned counsel for the petitioner to provide the freshly typed copy of the cost title to be retained on record. And thereafter, the city registry shall also be corrected. Next paragraph. By filing this repetition on Article 226 of the Constitution of India, the petitioner has assailed his hearing disability assessed at 23% by the medical board held on 2/8/2023 for re-verification of PWD status. W is small, PWD status. And for the direction to appoint him to the post of junior inspector of the auditor of cooperative societies. Issue notice, including notice on the prayer for interim relief returnable on, give a date after 5 weeks. On so and so. Requisite extra copies of the requisition be served on the state and departmental council within 2 days. The claim of the petition shall be subject to the outcome of the writ petition. List on so and so.
24/7.
There was an interim prayer to keep a seat vacant.
No, we are not giving any post vacant. Okay. We have said that it will be subject to outcome of the writ petition.
Lordship. One more humble prayer, Your Lordship. There's another repetition. There were two medical reports. The second one we are challenging here. There's another one which we have already challenged. It is repetition number 2321 of 2024. It will be tagged with this, Your Lordship.
This was along with WBC. Give the number.
WBC 2321 of 2020. 2321 of 2024.
SC corporation will be reflected in the cost list. SC corporation.
Okay. The registry shall reflect the name of the standing council for various departments of the cause list while listing the matter next.
Applies, the Lordship.
Yes, 31.
Item 31.
I have talked with the assistant DLR. The appellate of the DLR is out of station in Madhya Pradesh for election duty. Lordship. He will back on 6th and 6 onwards. They will start.
We'll start functioning. Okay. Then we issue notice. Sorry, we relegate you to go approach the appellate authority. The director of land.
Records. Land and revenue record.
Land and the director of land records
And service.
and survey, right. Heard Dr. B.N. Gogol and counsel for the petitioner. Also heard
As
Yes.
doctor.
M. Bhattacharya and
As the, sorry.
additional senior government advocate.
Yeah.
Appearing for respond number 2, 3, 4, 2, 3, and 4.
Yes, sir.
Two I am appearing, Lordship.
2 you are appearing.
Three and four, Lordship, I have paid.
Okay, 3 and 4.
Yes,
So,
Lordship.
1 and 2.
1 and 2 I am as doctor.
Mr. S. Datta, and it's standing counsel for the revenue department representing respondent number 1 and 2. You write 1 and 2 first, then 3 and 4. In view of the nature of order proposed to be passed, issuance of notice on the respondents, including respondent number 5 is dispensed with. Next paragraph. rejection of the candidature of the petitioner for the post of Gaon Pradhan of Pug. What is the?
Kalakusi.
Hmm?
Kalakusi, Nalbari.
Pug Kalakusi.
Lots.
PUB dash Kalakusi, KALAKUCHI village in the Y district. By selection list dated 9/2/2024. Is has been assembled in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. At the outset, the learned standing counsel for the Revenue Department, as well as the learned additional senior government advocate, has submitted that the state government has nominated the Director of Land Records and Survey from a Government of Assam as the appellate authority for the purpose of adjudicating disputes under section 163 dash
Executive instruction 162.
160, okay, by sorry, not section. Executive instructions number 162 dash capital C of the framed under the Assam Land and Revenue Regulation, 1886. Next paragraph. The learned standing counsel for the Finance Department has submitted that at present the said authority is engaged in election duty and is likely to resume office only after a week. Next paragraph. In view of the said submissions made by the learned State and Departmental Council, the court is of the considered opinion that it would be appropriate to relegate the petitioner to approach the appellate authority constituted under section under executive instructions number 162 dash capital C under the Assam Land and Revenue Regulation, 1886. Full stop. With such liberty, this petition stands closed.
Item 4.
May I PP for lordship? My lord,
Yes.
my lord, it's contempt.
What is the, where is the order?
My lord,
1912.
order, my lord, annexes 6, my lord, page 37 and 38, my lord. Very important, my lord.
Is 738.
Yes, my lord. Para 3 and 4.
What was the time given?
My lord, in that said order, my lord, no time has been framed, my lord. Now,
Okay, then we shall notice. But Mr.
NK Muri, my lord.
MK
Yes.
Mored and counsel for the petitioner. Next paragraph, alleging willful disobedience of order dated 19/12/2022 as by this court in WPC 8119 of 2022. The present contempt petition has been filed. Next paragraph, issue notice returnable on so and so, give a date after 5 weeks.
24/7.
The petitioner shall take steps within 2 days for service of notice on the respondents by registered post with AD. Next, the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next, the pendency of the contempt petition shall not be a bar for the respondent authorities to comply with the order of the court.
I am obliged, my lord.
Item 6.
May please, your lordship.
My lord, this matter relating to the, my lord, non-payment of family pension, my lord. Petitioner's husband rendered, my lord, 27 years of service, from, my lord, 15/7/1969. And he
issuing
died in
notice-
harness on, my lord,
They're
69
issuing notice in the
1990.
matter.
My lord.
They're issuing notice in the matter. But Mr. M. Islam, the counsel for the petitioner, also heard Mr. P. Henry Leonard, standing counsel for the respondent numbers
1, 4, and 6.
1, 4, and 6. And Ms. A. Talugal and government advocate appearing for respondent number
2 and 5 lordship.
2 and 5.
Action department.
And for finance shall be there,
Over.
Mr. V. Gogoi, standing counsel for the finance department, the project respondent number 3. 7 who will be appearing, treasury officer, he will appear, I think.
Finance. Normally finance actually.
Finance, 3 and 7. Next paragraph. The petitioner projects that her husband, late Jatindra Mohan Sukla Vaidya, had rendered continuous service of more than 27 years as grade 3 employee in the as secretary of Hasanpur GP, HASANPUR GP under Karimganj Zilla Parishad, and had died in harness. First off, it is projected that the petitioner, upon death of her husband, is entitled to family pension and other retirement benefits, which has not been released till date. Hence this petition. Next paragraph. In this petition, claiming benefit as per order of this court in the case of what is it, WA 145, which is
Oh,
that
my
there?
lord, page number 32.
32.
State of Assam versus my lord Syed Mohammad Fazle Rabbi. Page 32, annex of 3.
So the cumulative benefits as granted by
Judgment dated 24/3,
judgment dated
24/3/2010.
24/3/2010.
Operating part page 59.
Passed by this court in WA 145 of 2009. Give a dash, the state of Assam and another versus Syed SYED. Next one is Muhammad MD. Next one is firstly FAZLAY. Next one is Rabi RABBI and other connected cases. Next issue notice. Returnable returnable on, give a date after 4 weeks. Returnable on so.
17/7.
Requisite extra copies of the requisition be served on the Rana State and Departmental Council within 2 days. Next, the pendency of the reparation shall not be a bar. For the respondents in the Panchayat Department and Rural Development Department to examine the claim of the petitioner and to pass appropriate orders.
But he also filed representation, man. She also filed representation that may be considered it in the meantime. Man.
We are passing a judicial order.
Highly oblige your lordship.
So just say one more thing, before that, before issuance of notice, you say, the additional affidavit An additional affidavit filed by the petitioner has been brought on record.
Highly obliged, your lordship.
Item 36 for admission.
But that matter, your lordship has heard it at length. The date of the DPC, there was no charge sheet.
Oh, acha, yes,
Yes.
yes.
That something has been brought in the court's record showing filing of the charge sheet that we are aware and we have informed your lordship that the charge sheet was filed on 23/3/22. But that doesn't change the situation, right? It doesn't change the case law cited by me.
There is. Okay, I get it.
And all the case laws I have pointed out, so
Yes.
they proved it again, man. If necessary, I can make a small note and provide it.
No, not required.
On
You're,
the
you're
date of
relying on
the
5 judgments.
Yes.
Union
Yes.
of India versus
On
Anil
the
Kumar
date-
Sarkar,
Yes,
Janki Raman,
Yes.
R.S. Sharma, Dolly Loi,
yes,
and Hiten Kalita.
yes.
These are
On
not
the
there.
date of the DPC, if the charge sheet
It's
has
not
not
there.
been issued, then you cannot, you'll have to open. So direction has to go from lordship to open the seal cover and give due relief to the petition.
Anything more you want to say? No.
Lordship, actually, the matter, my colleague who is appearing in this matter, Lordship, so
Should
I am
have.
not at all conversant with this matter, Lordship. If your Lordship may kindly take it up tomorrow, Lordship.
Mr. Dhar is not
Because,
there today.
yes, Lordship, because of waterlogging, he has left
Okay,
home,
tomorrow.
Lordship.
Let him make his submissions, Mr. Dhar.
So I have no
the-
much idea in this matter, Lordship, since
But
he is
has placed
appearing.
his- He has placed his facts on the.
It's okay, not required, but let him make his say. You may not be there tomorrow. Mr. B.D. Das, the senior counsel, assisted by Ms. Adeka, counsel for the petitioner. Next,
I was not.
Ms. M. Bhattacharya, learned additional senior government advocate, has submitted that due to waterlogging, Mr. R. Dhar, learned additional senior government advocate, who was heard on the last date, is not present. So accordingly, matter stands adjourned today, list on, give a date tomorrow.
Tomorrow.
4/6/2024.
Lordship.
2 PM.
You make a prayer, to consider.
Okay.
You make a prayer in the morning, we'll take it up at 2.
Lordship. Deeply obliged, Lordship.
Thirty-seven.
In this matter, Learned Government Advocate was directed to obtain instruction. I have got already accept the financial benefit minor person to filing of the petition.
What is the nature of financial relief?
Lordship, I prayed that on the date when my juniors were promoted, that retrospective effect be given to me.
Okay.
I have got double promotion, my lord, in the year 2024. Recently, I was promoted to deputy director, insurance deputy director. Other prayers of the repetition have been, lordship, already complied. Already have,
But the financial benefit, Lordship, there is no mention in the prayer, Lordship. And I am not aware, Lordship, whether the
We
prayer
permitted to
portion has been
we
rectified,
permitted
Lordship.
to submit a representation for financial relief.
Yes,
lordship
Lordship.
may do.
Okay. Miss, upon instructions, Miss B. Bhuiat and Miss Senior Counsel, assisted by Miss
Be Bora.
B. Bora, the learned counsel submits that except for the financial benefit, comma, the relief claim, the other relief claimed in the writ petition has been granted to the petitioner. Next paragraph. Ms. M. Bhattacharya, an additional senior government advocate. For respondent numbers,
Lordship, I am appearing for respondent number 1, 1, 2, 3,
1
4,
to
up
6,
to
1 to
5,
7.
Lordship.
No, 1 to 7, I think.
Lordship, Lordship 7.
1 to 7. Mr. Bhattacharya, you are for
My lord,
8.
I 9, my lord, because finance have been, my lord, later on implemented.
No, constitution has not been amended. Constitution has not been amended.
If my lord may be perused, my lord, the order dated 2/4/24, my lord.
No, this is only saying that this court this court also requests Mr. S. Haria, Standing Counsel for Finance Department, to coordinate with Mr. Goswami in getting the instructions. So you're not impeded.
Finance not implemented.
Not
my lord.
implemented.
But we have received the instruction.
Okay.
Our instruction, Lordship may kindly peruse it, my lord. Lordship may kindly peruse.
You see, none appears on call for respond 8. Stop. Mr. R. Bhattacharya, Learned, Standing Counsel for the Finance Department, appears pursuant to order dated 2/4/2024.
Yes, instructions, if Lordship may be pleased to come to the second page. There, my lord, the second paragraph. After careful examination of the proposal, Finance Department queried the above fact, had endorsement dated 15/2/24, reply of which is still awaited. Now, we have taken, my lord, verbal instruction from the Finance Department. They say, my lord, the reply has not yet been received from Food and Civil Supplies Department. Because here the issue will be with regard to retrospective giving effect of the promotion. His junior, petitioner junior, Sam Mahanta, he was, my lord, since EP was, my lord, pending with regard to the petitioner Dhruvaduti Rekha. So therefore, in the meantime, once Sri Sopan Mahanta, he was, my lord, promoted. Then, my lord, in the meanwhile, my lord, the DP came to be dropped in respect of the writ petitioner.
We don't say anything, we say that they will make a representation.
Lordship, I have an instruction, but this is half without annexure. This thing has been clarified, Lordship. This thing has been clarified in the letter dated 15th May 24, Lordship.
The problem is that you are both working, but on different dates. His letter is 24th April.
Yes.
You respond on 15th May.
Yes, Lordship.
So definitely finance will not know.
Lordship, because your Lordship actually put some query on me, Lordship. That's why I have communicated with the department, Lordship. But the annexures are not here, Lordship, since it is downloaded from the mail, Lordship. Here,
No, that's
Lordship.
okay. This doesn't answer the query of Ms. Mia.
Yes,
See, The
Lordship.
problem is that she's saying that everything is redressed except pay, the financial benefit. Doesn't address that. Is present, next para. As the petitioner has been granted substantial relief, the court is inclined to close this petition with liberty to the petitioner to submit a representation before the competent authorities for claiming financial benefit with effect from the date from which she has been made entitled to promotion.
Yes.
Okay. Next, the instructions produced by the learned additional senior government advocate as well as the learned standing counsel for the finance department is returned.
Lordship, I'll file a representation with the
Yes, Lordship, this
immediately
will be
mentioned
better.
manner.
Okay.
As per para 7 observed in the letter, Lordship. Because it is clarified that both the
it is-
petitioner and as well as the private respondent, Lordship, both were given the retrospective effect on the same day, Lordship, 27/8/2015, Lordship.
Doesn't answer the query, court query. She's more interested now in finance, financial benefit. That doesn't answer that.
Lordship.
No.
Because the
It is hope-
financial
it is
benefit
hope that
has to be accorded. to the-
It is hoped that if such a representation is submitted, the competent authorities shall take a decision thereon, preferably within a period of 4 weeks.
Lordship.
My lord, the petitioner will lay a fresh representation.
Yes, I will.
From the date of receipt of that representation.
Okay.
Submit the first representation. We are returning our instructions.
Lordship.
Lordship may keep it as a part of the record with a mark, my lord.
38.
Yes, yes. Deeply obliged, your lordship.
I am obliged.
May I please your lordship, in this matter, lordship, I have received the records, lordship. I pray for some accommodation because lordship, I have misplaced my brief, lordship. Some accommodation, lordship. I've received the records, lordship.
Okay. Well, both sides are represented. Right. Mr. Assessor and CGC has submitted that due to advertise, he has his he has misplaced his brief. So how it is submitted that he has received the records. As per order dated 10/5/2024. That's per. As paid for list on when
Any date within 10 days, lordship, any date, lordship, 10, after 10 days, lordship.
10 days. Well,
Lordship.
6/2024.
Lordship. Obliged.
Item 40 to 45.
Yes.
Might be the lordship. My lord, in this case, my lord, your lordship also already passed an order that prepared a list of dates. My lord. Now, basic case before your lordship is that the petitioners were employees of
Very interesting name you have, gang.
Yes.
Yes.
Now let me explain the case in gist, my lord.
Change করছে না পৃষ্ঠা করে?
Hmm. Very good, yeah.
Yes, Mr. Hospital.
No, my lord. No, my lordship. Facts in.
Yes.
Facts in brief is that in food storage depot at New Guwahati, the petitioners were working as Group D workers carrying loading and unloading operations. Now, in course of their duties, they may require to replace the torn bags. Now, this depot was audited by CAG. And according to that audit report, the supplied bags is less than that of the replaced bag. So he was of the view that excess payment was made. Now, a committee was constituted in this regard. And this committee was of the view that the excess payment was made, and thereafter, deductions were carried out. Now, at this stage, after 5 or 6 years, at this stage, we approached before this honorable court. And your lordship has dealt with one of this case that your lordship is paid at 132. That 134, your lordship judgment. 134 question order. Okay, 132 page of that.
Yes.
Oh, okay, it starts from 129. Lordship, got it? By filing this heat petition under Article 226 of the Constitution of India, the petitioners have assailed the action of the respondent for recovery of alleged excess payment made to the petitioner from the monthly salary wage payable to the petitioner. The case of the petitioner, in short, is that they were assigned the task of filling up food grains from the torn gunny bags to new gunny bags. As per CAG report, against 57,521 gunny bags issued for filling up of grains during October 2013 to March 2014. Output slip for 12,43,312 bags were made, thereby resulting in excess of certification of work for filling up of 11,85,791 bags, and accordingly excess payment of incentive was calculated by CAG, that is CAG audit report. Rupees 330.84 lakhs. Accordingly, recovery has been initiated from the petitioner. The learned senior counsel for the petitioner has submitted that the rigorous process of account for work done is explained in paragraph 9 of the writ petition. Writ petition. Therefore, it is submitted that the assuming but not admitting that there might have any lapse on the part of the petitioner, the respondent ought to have been given a reasonable opportunity to the petitioner of being heard before initiating recovery process. The learned senior counsel for the petitioner has also relied upon a such and such version, Rafiq Moshi's case, 2015 5 SCC 334. 5 or 4? 4. Oh, it should be 4 SCC probably.
This
The
judgment
learned-
you don't have to read. The judgment you don't have to read.
No. The learned counsel for the respondent has referred.
No, don't read that judgment. It's not.
No, I'm okay. Now, my lord, what is so far your lordship judgment is concerned, ratio of the lordship judgment as it appears to me is that if there is a case of fraudulent transaction, then the Rafiq Mushi's case will not be applicable. That was tentative view of your lordship, as I have understood. And your lordship was of the view that even if if there is a case of fraud, then the delinquent should have an opportunity of being heard. As the instant case, nothing has been done, so no recovery should be made. That was the ratio as I have understood. Now, while the last paragraph, your lordship, at page 133, before parting with, on paragraph 9, on the facts and circumstances of this, there appears to be no need for the court to return the finding whether the ratio of the case of Rafiq Mushi would help the petitioner in any manner whatsoever. As such, the said issue is left open to decide for a more appropriate course. Number paragraph 8 is very much clear. In the light of the discussion above, the court is of the considered opinion that the action of the respondent under the facts of this case is not found sustainable. That was your lordship's clear view on the facts and in law. And as such, the court has no hesitation to set aside the action of the respondent in effecting recovery of money from the salary of the petitioner on account of alleged fraud committed by the respondent without disclosing before the court regarding passing any written order to that effect. Resultantly, the respondents are jointly and severally restrained from making any recovery from the salary of the petitioners on account of the finding returned in CAG audit report dated 25/10/2015. Now, in the last paragraph, your lordship made an observation. Before parting with this record, it is made clear that the order shall not preclude the right of the respondent to hold disciplinary inquiry or disciplinary proceeding against the petitioners. So it is confined with respect to these petitioners only. And from making recovery after giving a reasonable opportunity of hearing to the petitioners in accordance with the procedure prescribed. It is also made clear nothing contained in this order shall prejudice the petitioners or the respondent in any proceeding whatsoever, which shall be decided in its own merit without being influenced by this order. Now, thereafter, what happened, Miller? They gave a show cause notice. And no inquiry officer was appointed, no presenting officer was appointed. We were called upon to give our reply. We gave our reply. And they simply said, no, your reply is not satisfactory. And so whatever deduction we have made, that is justified.
Where is that order?
Now,
Where is that? Where is that document?
no, so far, 2-4. Now, another thing is, Millard, that order was restricted to the WPC number 1094. Now, what they had done, taking advantage of this order, they have applied the ratio of this order to the other cases. And all the petitioners were called upon to submit their reply. Millard. No, so just now your lordship is inquired about where is that order. I don't have the order with regard to the 1094, but I have the order with regard to this petition.
Yes.
That is, your lordship will find.
Is it page 146?
If it be in a position, page. Not 136. They were. One 36 is the show cause notices.
No, 146.
146. Yes. This is one of the order. Prior to that, Millard, we approached before, Millard, hold on, let us go through its order first. Then, let us go see. Now, whether the order passed in 1094 is applicable in this case also, that is also a question. Millard. So, I raised this point before this honorable court, and this honorable court has also passed an order in this regard. I will come later on, Millard. 140, 40,
146.
148. Whereas show cause was issued to see such and such. A similar order was passed, identical order was passed to all employees by office serial number such and such. Whereas reply received from such and such, Sirajul Kiyot, whereas the personal hearing was held on 21/2/30 December in pursuance of DO committee of FSD Hojai. Whereas the written reply submitted given in the personal hearing has been examined by the undersigned. So cause issued, we submitted a reply and that reply was only examined. And Sri Sirajul Kiyot Shadar, such and such has stated and submitted the following, that FSD NSG is high transaction depot and receipt of numerous racks are being done. Many wagons are lying CTL bags. Rain damages bags are also received in racks. The stocks received also have supplied, has spilled and scattered bags, as these are to be stitched and refilled, etc. As these are to be stitched and refilled, etc. These obviously be more than new gunny bags supplied output refilling bags. What they wanted to say that they have stitched some bags and make it workable. these bags are to be stitched and refilled. These will obviously more than the new gunny bags supplied, outfits the refilled bags. Audit had no document to prove excess certification in audit report except the figure of new gunny bag supplies. Now, what they want to say, the audit has only counted the new gunny bags supplied. Audit has not counted the bags which were repaired. No connivance done as output work done is a matter by depot staff. No misconduct done. That is our reply, Lord. Whereas whereas it is undeniable, and in fact, the crux of the matter is that as per CAG audit findings for the period of October 2013 to March 2014, only 57523 new bags were issued, whereas refilled bags have been shown as 12,43,312, which is abnormally high to the huge extent. Sardars, Mandals stating that they are oblivious to the excess bags, to the excess. Fact is also not sustainable, as they have to supervise the operational and seasonal and experienced workers. They are to do well versed with the depot procedures. So this is depot procedures, and incentive was monthly paid allowed. His or his Shardas Mandal, etc. Now let's come to page 147. The subsequent General Officer Northeast audit also found the excess certification as high and an amount at FSD New Guwahati. Refill bags showing beyond the quantity supplied to the tune of 2,000% clearly and evidently abnormally and incorrect certification. At no point of time, workmen had objected on the salary credited with their incentive payment on higher side, whereas the depot staff are responsible, but role of the connivance of Sardar Mandal is also evident here. Substantial undue gains on account of incentive payment has been given to the Sardar Mandal posted at FSD Guwahati. Hence, considering the above, undersigned comes to the conclusion as follows. It is a case of excess payment made to the handling laborers and other Sardars Mandals posted at FSD Guwahati. Deliberate and consciously he had received incentive amounts for work which they had not done. They had not rendered any service. This has caused a huge loss to the corporation and the public exchequer, as pointed out by audit. The primary responsibility lies with the depot staff. However, in connivance with the FCI employees of depot, such unjust enrichment has been received. Hence, Sri Siyajil Kiryos Sardar Mandal is found liable for the loss of the department, loss of the corporation, and on account of fraudulent excess certification shown as pointed by the CAG adult. Taking lenient view, the undersigned disposes of the cases with the direction to recover only the amount found paid to him fully in excess provided, pointed out and assessed as assessed by CAG audit, FCI J. Sachin, and in terms of the subsequently by FCI DOJ to meet the ends of justice. So, Lord, what happened in this case, Lord, a show cause notice was issued. We submitted our reply to this show cause notice. No inquiry officer was appointed. No presenting officer was appointed. Only the person concerned were called upon to appear in the personal hearing. They appeared and they have said so, whatever they wanted to say, they have said. Their submission was recorded. And based on that record, Lord, this order was passed. And what is the consequence of this order? That in connivance with the other staff, you have done so. Whereas we have specifically denied. Rightly or wrongly, we have denied these things. So when there is a specific denial of the allegation, it was incumbent on the part of the FCI authority to appoint an inquiry officer to inquire into this matter. No inquiry officer was appointed, no evidence was taken. Only because, only by submission of the written reply, they came to this conclusion. First thing is that, Lord. Second thing is my Lord. Now, second, that is my first point. The second point is that what I have understood from your lordship judgment is that the Rafiq Mushi will not be applicable if there is a case of fraud. But if there is a case of fraud, you must hold a departmental inquiry. That is what I have understood, subject to your rectification by your lordship. And your lordship was of the view, yeah, we should not go at this stage, we shall not look into this fact. As you have submitted your affidavit, and your affidavit, you have specifically in so many words stated that this is a case of fraudulent transaction. And if it is a case of fraudulent transaction, there is no material in record to substantiate your action, because you have not given any opportunity of being heard or any opportunity and your lordship specifically set aside their action. However, while delivering the judgment, your lordship made an observation, all that you can go with an inquiry. Now, in taking advantage of that observation, what they have done, for all and every worker, they should once sing stereotype show cause notice. And all the workers were called upon to submit their reply. And of course, the reply submitted by the workers are also stereotyped. Their basic contention was that what I have stated in paragraph 9 of my petition. I will not trouble your lordship too much. Their basic contention was that, yes, we are to replace the Gandhi bag by new bags. Sometimes we used to replace the bag by repairing the thing. A bag is torn. Then instead of replacing this bag, instead of throwing out this bag, we get it repaired, and then again we fill up with that funds. That was their contention. And they have submitted their contention. Whatever may be, their contention may not be correct or may be correct, whatever may be. So it is a case of, if it is a case of fraudulent transaction, you must hold a departmental inquiry. Summary inquiry they have conducted. Now, what is their allegation? your allegation, your lordship will find at page 134. Married. Well, only one focus notice. Let us read it. See, such and such Sardar FSD Hojai. Now this person is now working at that relevant time when this show cause notice was served. He was transferred from FSD Guwahati to Hojai. And so that notice was served on him when he was working at Hojai. See, Sardar FSD Hojai, while working as Sardar at FSD New Guwahati, with effect from 2013, October 2013 to March 2014, failed to maintain absolute integrity. That is very much important, brother. Absolute integrity, lacked devotion to duty, and failed to safeguard the interest of the corporation. Whereas a CAG team conducted an audit of FSD New Guwahati and had submitted its report by number such and such and observed that excess certification of work via a refilling of bags to the tune of such and such was bags during the period of October 2013 to March 2014 was done, resulting excess payment made to the depot laborer, FSD Guwahati, to the tune of such and such amount. Whereas the internal investigation committee formed by Geo has examined and computed the gang-wise excess payment made for excess certification of work, a refilling of bags to the tune of such and such bags during the period of October 2013 to March 15 and observed a CAG report. Accordingly, this computation of labor-wise excess payment made to the departmental labor has been done by FCI DO Guwahati while being posted at FSD New Guwahati during the period October 2013 to March 2014. Details of excess payment is made enclosed herein. Whereas you have ignored your duty. This is the basic allegation. What is the allegation? Whereas you have ignored your duty as a responsible handling laborers, Sardars, mandals for the period October 2013 to March 2014 and failed to bring the notice to FCI to incorrect certification of the work at FSD New Guwahati for which excess payment was made. Actual allegation is that you have failed to, you have ignored your duty handling workers for the period such and such to bring the notice of the FCI. So it was according to it was incumbent on the part of the delinquent to inform the FCI authority that, sir, we are getting much salary as we should have get, and we have failed to point it out the incorrect certification. That is the basic allegation. Whereas, if you would have acted diligently, so negligence is there, then the correct certification of work would have been made. So only thing is that the negligence of duty is there, made. Excess payment made by FCI could have been avoided. The corporation would not have suffered such huge financial loss pointed out by the CAG auditor. So the basic allegation that you have failed to discharge your duties in proper way. That is, in other words, you can say you have not acted diligently, or you can say that you have acted negligently. Second is, had you not been negligent, then probably this excess payment would not have made. How that they have attributed this negligence? They have lodged an allegation against us to the effect that as we are getting an excess amount of incentive, it was incumbent on our part to point it out to the appropriate authority that you see that excess certification was made, and for that reason, we are getting excess payment. That I have understood. Now, Lord, if we consider these two things to be correct, then also what I subject to your lordship's verification, whether is there any allegation of fraud? Whereas you have ignored your duty as a responsible handling labor bundle for the period of October 2013 to March 2014. Failed to bring notice to the FCI. What is the? Failed to bring a notice to the FCI, incorrect certification of works at FSD New Guwahati for which excess payment was made. There is no whisper about the fraudulent transactions. Next paragraph, Lord. Whereas, if you would have acted diligently, the case, then the incorrect certification of work would not have been made, and excess payment made by the FCI could have been avoided. Negligence. And the corporation would have suffered such huge financial loss pointed out by the CAG report. Now, my lord, let us come to your lordship judgment. The ratio of the judgment is that if there is any fraudulent transaction, then you can deduct the salary, but by doing so, you must hold a departmental inquiry. So that departmental inquiry should indicate that you are a party to a fraudulent transaction. Now, what is though in a first paragraph, at the very beginning, they have indicated something, failed to maintain what they have indicated, failed to maintain absolute integrity. They have said so, but ultimately, my lord, their conclusion is based on these two things. Now, if I go through your lordship judgment, my lord, then probably the Rafiq Mush's case will be applicable here. For the time being, may I read the Rafiq Mush's judgment?
Not required, we were aware of it.
No. Now, let us consider, second point is, let us consider that it is a case of fraudulent transaction. Firstly, what I would like to impress upon your lordship, because
Rafiq Masih also says that the payment should be made without his indulgence.
Should I read this?
No, not because this is, we are aware of it.
Only
payment must have been made without his involvement.
Yes. Paragraph 10 or 9.
Without his fault.
No. Commercial. It is at page 345. No, it is not possible. Paragraph 18. It is not possible to postulate all situations of hardship which would govern employees on the issue of recovery where the payments have been mistakenly been made on decisions referred to the herein above. We may, as a remedy reference, summarize the following few situations wherein the recoveries by the employees would be permissible in law. Number one, recovery from the employees belonging to class 3 and class 4 service service or group C or group D service. Number two, recovery from retired employees or the employees who are due to retire within 1 year of the order of recovery. Number three, recovery from the employee who, when the excess payment has been made for a period in excess of 5 years before the order of recovery issued. Recovery in case where the employee has wrongfully been required to discharge his duties higher post and has been paid accordingly, even though he should have rightfully been required to work against an inferior post. Number 5, in any other case where the court arrives at a conclusion that the recovery, if made from the employee, would be iniquitous or harsh or arbitrary to such extent as would far outweigh the equitable balance of the employer's right to recover. Now, your lordship made an observation that yes, at this stage we should not consider the case whether the Rafiq motion is applicable or not. But as you have yourself have stated in your affidavit that they were involved with a fraudulent transaction, it was incumbent on your part to hold a departmental inquiry. For that reason, probably your lordship had said so. Now, my lord, if we go to their conduct, my lord, what transpired that no departmental inquiry was held.
Yes.
Now, your lordship was specifically stated at page 134. No, 130. No, page 131, your lordship. Please. Paragraph 5.
Yes.
There is no material in the affidavit in opposition filed by the respondent which discloses the petitioner that the petitioner from whom the recovery is sought to be made were allowed to participate in the audit process conducted by CIJ. There is also no material on record from which it can be presumed that the respondent had initiated any disciplinary proceedings. Here only the show cause notice was only issued. No disciplinary proceedings was initiated. Any disciplinary proceeding against the petitioners and having granted reasonable opportunity of hearing, the petitioner arrived at a conclusion to the effect that the petitioner is guilty of misconduct or fraud, or having caused wrongful loss to the respondent. The learned counsel for the respondent has not been able to show from the service jurisprudence that any provisions of any statutory act, statutory rules, or rules framed under Article 309 or standing orders or office memo was issued by the competent authorities of the respondent, which empower the respondents to make recovery of money from the salary of the petitioners, without giving them a reasonable opportunity of being heard. Needless to mention here that since no disciplinary inquiry, is very much clear, no disciplinary inquiry or of inquiry of disciplinary proceeding is shown to have been initiated, submission of charge sheet to the petitioners could be demonstrated, but no charge sheet was issued here, only the show cause notice. Charge sheet to the petitioners could be demonstrated, and consequently the respondent have not been able to show that any order was passed by the disciplinary authority for recovery of any money from the salary of the petitioner. Similarly, the learned counsel for the respondent has not been able to show any adverse remark made by the CAG report, which enables the respondent to directly go for recovery without putting the petitioners to the notice. It has not been shown that there is any finding of any court of law holding the petitioner guilty of fraud or excess drawing of wages and or incentive of work shown to be done by committing fraud. Similarly, no document is annexed to the FPTP in opposition to show that an FIR had been lodged by the respondent alleging commissions of fraud by the petitioner in connivance with the others. Moreover, assuming from the Annexer E and Annexer F of the FPTP in opposition filed by the respondent that the petitioners had a knowledge of the intention of the respondent authorities to recover losses by deducting money from the salary of the petitioner, but no legal provision could be shown that such knowledge is substitute to show cause notice. What they wanted to say that you know all these things, so you have not served any show cause notice, which is well settled requirement for initiation of any disciplinary action against any delinquent employee. Thus, in other words, recovery is sought to be made from the salary of the petitioner without any finding to hold that the petitioners were guilty of fraud. This is basically repeatedly said that is the guilty of fraud or any other misconduct, or that they are guilty of fraudulent withdrawal of money sought to be recovered. There is nothing in the FPTP in opposition filed by the respondent from which it can be gathered that the amount of money sought to be recovered from the petitioner has been quantified after putting the petitioner to the notice in FPTP in opposition filed by the respondents. The respondent have not produced any order in writing that was served on the petitioners before stating or deduct money from the salary from the petitioners. Therefore, in the light of above decision, court is of the, that is, I have already read. So, what your lordship mind at the point of delivery of judgment, that you see you have deducted some amount, and the petitioner has come with before this honorable court to apply the Rafiq Moshi's decision. Now they filed their FPTP in opposition, and in their FPTP in opposition, their basic thrust was that it is a case of fraudulent transaction in connivance with this. Then your lordship say express his view, even if we are assuming that this is your allegation, then you should have conducted an inquiry. And as you have not conducted any inquiry, so it cannot, your action is not sustainable. That was not, and we shall examine the case, whether the Rafiq Moshi's case is applicable here or not. That was the ratio laid down in 1094, not in all these cases. Now, what they have taking advantage of this order passed by your lordship, they have made it applicable to all other cases. Now, this point was pointed out to this honorable court, my lord, and this honorable court also made an observation in this regard. That
I've seen
your
that
lordship,
page 203, I've read that.
huh?
Page 203, I've read that.
Page
203.
Your lordship read it. This is Shwekya's order. That's all that. Then all that. No problem. I shall not trouble your lordship. So my case before your lordship, that there are two cases which is binding on me. One is your lordship judgment, and second is Rafiq Moshi's case. Now, so far your lordship judgment is concerned, that if it is a case of fraudulent transaction, then you must hold an inquiry. And though your lordship has not specifically stated so, but after reading and reading by your lordship judgment, it came to my mind what your lordship wanted to say. The Rafiq Moshi's case will not be applicable if there is a case of fraud. Probably, though it is not specifically stated, but it is correctly that Rafiq Moshi's case will not be applicable if there is a case of fraud. Even it is probably, because though it is not specifically stated, but even if it is a case of fraud, then it is incumbent on the part of the employer to give the delinquent employee to proper opportunity. Now, fraud is a serious allegation. So a summary inquiry will not be, by conducting a summary inquiry, nobody can come to a conclusion that you have committed a fraud. That is one aspect, my lord. Second aspect, my lord, so far this case is concerned, they have not conducted any regular departmental inquiry. So what is the regular departmental inquiry? Is that you file initially you should submit a charge for show cause. Delinquent shall submit his reply, and if the concerned authority is not satisfied with the reply, then they should decide to initiate a departmental inquiry. Before proceeding with the departmental inquiry, they should frame a charge sheet, and all these things are to be done. One inquiry officer is to be appointed, one presenting officer, a regular inquiry has to be carried out. But nothing has been done. This is one aspect of this case. Again, secondly, if we go through your lordship judgment, that if there is a fraud, then you must hold a departmental inquiry. Now, if we go to the charge sheet, show cause notice, there is no specific allegation of fraud. Only thing is that you availed excess payment, knowing fully well, without informing the matter to the departmental higher up. And thereby, you committed a negligence. Or they have said that you have not acted diligently. So even if we go through this thing also, then also, my lord, your lordship judgment is not applicable in these cases. And so far the departmental, if we proceed with the departmental inquiry by taking a notion of fraud, then a regular inquiry is to be conducted, is required to be conducted, but no such regular inquiry has been done, my lord. So in view of these things, the action resolved by the management is not fair. That apart, my lord, so far these cases are concerned, they have not taken any leave to apply the 1094 of 2021 to other cases. These are my basic arguments, my lord, before your lordship, and my learned friend may argue, and then I can. Now it is 4:20. All right. Please.
Okay. Still there.
Lordship will kindly have a look at the prayer at page
I
12.
think other matters I will not be able to take up.
No, now it is now 425 already.
No, father, their learner council sitting, I can't take up the other matters. Yes,
445,000.
No, not all, no, I'm not for that.
no, for other matters.
That's all.
For only other matters.
Yes,
My lord will kindly come to page 12 of the writ petition. The prayer made, my lord, in the writ petition. Page 12. Is the lordship got it, my lord?
yes.
Prayer is, in the premises aforesaid, pray your lordship may please to admit this petition call for the records and show cause being shown. Said as the letter dated 29/1/2012. This is the letter which was challenged, my lord. Page 42 is the letter, page 42. Page 42, my lord. This letter is addressed to departmental laborers, all the departmental laborers, and giving details, my lord. This letter was put to challenge by altogether 113 departmental laborers, my lord, by filing 10 different writ petitions at the same time. 10 different writ petitions. And 4 of them was listed before lordship on 25/8/2021. And lordship has disposed of those 4 writ petitions, my lord, not the others. This remaining are the present batch of petitions. All these were filed at the same time, making the same prayer, same challenge, same allegations, same cause of action, no difference. Same. Therefore, my lord, after your lordship has held in the 4 writ petitions that the action of seeking recovery, my lord, is not proper because they were not put to notice. And therefore, my lord, it's in the last occasion, I also said that I ought to have, my lord, apprised the court that we are proceeding. They thought, my lord, since it is the same challenge and your lordship has interfered with that, holding that departmental inquiry should be there should not be any incongruity in the inconsistencies, my lord, in the order. They have issued notice to all, my lord. They have notice to all and taken the action to all the departmental laborers. All these 10 who are involved, 113 departmental laborers involved in the 10 writ petitions. So, my lord, these orders, show cause notice or the order passed, are not put to challenge by the writ petitioners, either by amending the writ petition or by filing a separate writ petition. And there is an order, earlier order also, I don't remember the date, but Lord Lordship will find that, because of the subsequent event, they want to amend the writ petition. So that was not done. Now, secondly, my lord, my learned friend has taken a plea, my lord. There is an order, my lord, order date 16/11/2022. They sought to bring this on record or by amend the writ petition or otherwise. It was not done. Now, my lord, the petitioner has taken the plea that there was no departmental inquiry. Now, my lord, these departmental laborers are not like regular employees of the FCI, my lord. The FCI the FCI disciplinary appeal rule does not apply to them, my lord. The FCI disciplinary appeal rule says that this rule will not be applicable to them. Since they are industrial employees, their cases are covered by the certified standing orders.
Standing order is to high.
And in our affidavit in opposition, we have annexed a letter, my lord, annexed a letter written by their union leader, the president, before the executive director for holding a discussion on this at page 104, raising an industrial dispute. Page 104. Now, my lord, what happened, my lord? Since in the certified standing order, there is no penalty prescribed for recovery from the services, recovery from the employees. What we wanted to do is, since it is a huge amount, my lord, about the 3.7 crores, it was paid access to the beyond the services rendered by them. We wanted to make recovery. And this recovery process, we cannot initiate under the provision of the certified standing because there is no penalty prescribed for recovery. Therefore, in terms of the judgment passed to lordship, he said there should be an opportunity, natural justice principle, following of natural justice. Therefore, we issued a show cause notice. They were personally hurt and then passed the order. None of the orders are challenged, put to challenge before your lordship. And since this batch of 6 writ petitions and the 4 writ petitions disposed of by lordship are one and the same, and when your lordship in the other case has held that this is not the proper case for taking any decision on whether the Rafiq Masih applies or not, it may be taken up in a more appropriate case. My submission is this subsequent, this simultaneous writ petition, 6 are not the appropriate case, my lord. These are one and the same. They could have taken the plea by filing a separate writ petition challenging those orders, my lord. Then the lordship would have. Because here these orders are not put to challenge. These are one and the same. Therefore, this is not the more appropriate case for taking a different opinion by your lordship, because your lordship has already found that this is not the appropriate case. And even otherwise, Rafiq Masih's case has said not in case of mistaken payment. This is not a case of mistaken payment. Though it is not applicable, but in this case, the lordship has earlier held. Supposing when an overpayment is made or fixation of pay, and after 4 or 5 years want to seek the recovery, this is not proper. This is a deliberate receipt of the payment, my lord, for the services which they have not rendered. And I just point out to one observation, my lord, from the affidavit in opposition that I filed, my lord. If your lordship take up
21 is it appraisal?
affidavit of position, so it is. Our affidavit of position. Oh, yes, that affidavit that I filed on 19/7/2000, 19/7/2021 at page. I'll just take your lordship to the relevant part, my lord. Page 114. Page 114. Lordship got it, my lord.
Yes.
Page 114.
Paragraph internal paragraph.
Para na, it reported. Page 114. My lord, I read it, my lord. Examination, lordship got it, my lord. Examination of the records of job performance output slips based on which wages/incentives were calculated for the period from October 2013 to March 2014 of FSD New Guwahati revealed that a huge number of bags have been shown in the output slip as filling of bags on daily basis. For filling of bags with grains, bags should be issued from the stock of gunny bags. However, examination of monthly stock account of gunny bags of FSD New Guwahati for the above period revealed that number of gunny bags shown in the stock account as issue for consumption of depot was not tallied with the number of bags shown in the and certified by the depot in charge as filling of bags in the output slip. There was huge difference between the bags issued for filling of grains as to the stock and work certified by filling of bags and output slip. Against 57,521 bags issued for filling of grains during October 2013 to March 2014, as per stock account, total number of bags filled by lever as per output slip is 12,43,312. Thus, there was access certification of work in respect of 11,85,000. This is not huge difference. This cannot be possible. This is what the inquiry, found by the inquiry during the inquiry. And the amount loss is 330 crores. So this is, my lord, therefore, in no manner comes within the scope and ambit of FICMA. And since they have raised an industrial dispute, asking for a settlement there before and simultaneously they approach this court. And their workman category. The regular departmental rule does not apply to them. And the main thing is, my lord, that these orders which has been passed against them should be put to challenge. There should be prayer so as to enable your lordship to grant any relief to them. And natural justice was duly followed. The lordship wanted us to follow the principle of natural justice. We have done that. As I said, my lord, the departmental rule, FCI department doesn't apply to them. We had to only follow the principle of natural justice. That we have done adequately. Adequate opportunity of hearing was given to them. And then the order was passed. This is my humble submission of your lordship.
Your fact will take it up day after tomorrow.
Day after tomorrow.
But Mr. A. Das Gupta, Senior Counsel, assisted by Ms. B. Das, Counsel for the petitioners, as well as his argument is concluded. I'm reserving right to reply. Next paragraph. The submissions of Mr. P.K. Roy, known as senior counsel, assisted by Mr. S. Chakravarti, known counsel for the respondents, is concluded. Next paragraph. List on 5/6/22 for reply argument by the senior counsel for the petitioners.
Deeply.
This is before that you say, before that you say. Before this terms as well, you say that list of dates has been produced by, has been submitted by the senior counsel for the petitioners, which is made a part of the record. Part. Distance was a part of it. It would actually. It would actually.